Pursuant to notice, I now call up H.R. 3826, the Platform Competition and Opportunity Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3826, to promote competition and economic opportunity.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 3826, the Platform Competition and Opportunity Act of 2021, improves merger enforcement in the digital economy by shifting the burden of proof for transactions involving a dominant platform that are most likely to harm competition, eliminate consumer choice, and prevent new competition from entering the market. During the past decade, the platforms investigated by the committee were able to reinforce their market power and eliminate competition by acquiring hundreds of smaller firms that in several critical examples were competitors or nascent rivals. In May, the Washington Post noted that these firms dominate many facets of our lives precisely because they, quote, acquired hundreds of companies over decades to propel them to become some of the most powerful tech behemoths in the world, unquote. Importantly, antitrust enforcers closely reviewed only a handful of these transactions, and none were challenged. In other words, antitrust enforcers across both Democratic and Republican administrations stood idly by while what was once a dynamic and fast-growing market became concentrated and monopolized. This problem has only been exacerbated by decades of disastrous legal precedents that have imposed near impossible standards for antitrust agencies to satisfy in order to stop harmful mergers. The Platform Competition and Opportunity Act of 2021 targets this problem by prohibiting the largest online platforms from engaging in mergers that would eliminate competitors or potential competitors, or that would serve to enhance or reinforce monopoly power. This legislation strikes the right balance by shifting the burden to these firms, which are extremely well capitalized and employ thousands of attorneys, to show that these types of acquisitions will not harm competition. Earlier this year, then acting FTC Chairwoman Rebecca Kelly Slaughter testified before the Antitrust Subcommittee that this form of burden shifting would substantially help deter unlawful mergers. Not only will this legislation give antitrust enforcers the tools they need to block anti-competitive mergers, it will also deter companies from entering into these harmful transactions in the first place. All too often, antitrust enforcers are forced to spend time and resources on transactions that should have never made it out of the boardroom. Importantly, this legislation includes reasonable exceptions for the types of routine transactions that should not require enhanced review. H.R. 3826 is limited in scope and successfully remedies a problem that prevents our antitrust enforcers from stopping anti-competitive acquisitions in the digital marketplace. This bipartisan legislation would help promote greater competition, more choices, and increased innovation in the marketplace. I thank Congressman Jeffries and Ranking Member Buck for their leadership on this vital legislation, and I urge all members to support it. I now recognize the Ranking Member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This bill doesn't break up big tech. This bill doesn't even, frankly, stop mergers. It just shifts the burden. Under current law, the Department of Justice and the Federal Trade Commission can challenge mergers, despite the fact that the Obama Federal Trade Commission failed to do so. What this bill does is allow big tech companies to continue to engage in acquisitions mergers so long as they effectively have the permission of the FTC and the DOJ to proceed. Changing this standard in this way radically empowers the government's ability to apply pressure to these big tech firms in or outside the context of any given merger or acquisition. Cases would turn in no small part on the government's enforcement discretion, which means companies acting in ways that please their regulators. You can bet that those changes in behavior will not be in ways that give conservatives a better deal. These new and vague standards will be uncharted territory, resulting in significant incentive for companies to preview behavior with regulators and seek their blessing before acting. This bill doesn't break up big tech. As I said, the bill does not even prevent big tech from getting bigger. It does tell big tech that it can only grow if it does so in the ways that please the regulators, please the big government, please Ms. Khan, Ms. Slaughter, who the chairman cited. The merger activity of these companies is definitely something we should take a look at, but not in the way that is laid out in this legislation. I would urge a that we oppose this bill and vote no. I yield back, Mr. Chairman.
Gentleman yields back. I now recognize the Chair of the Subcommittee on Antitrust, Commercial, and Administrative Law, the gentleman from Rhode Island, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman. H.R. 3826, the Platform Competition and Opportunity Act of 2021, is an important piece of legislation that will prevent dominant online platforms from using mergers to increase their gatekeeper power and destroy competition. Dominant platforms have used acquisitions to neutralize competitive threats, reinforce the monopoly power, and expand their dominance into new markets. H.R. 3826 addresses this problem by requiring dominant firms to show an acquisition will not eliminate a potential competitive threat. Today, these firms are focused on transactions that allow them to control the technologies of tomorrow, like artificial intelligence and augmented reality. H.R. 3826 promotes a more competitive digital marketplace by giving antitrust enforcers stronger tools to stop anti-competitive mergers that snuff out competition online. This legislation takes clear aim at a problem plaguing digital markets. Over the past decade, antitrust enforcers have been too timid to challenge mergers, even in highly concentrated markets. When they have, courts have helped monopolists by moving their goalposts. As a result, our antitrust agencies are forced to waste limited time and resources reviewing mergers that clearly violate our antitrust laws. All too often, these transactions go unchallenged or are approved with toothless conditions. Contrary to the claims made by the largest tech companies, this legislation is not a merger ban. Far from it. This bill acknowledges the obvious. The digital markets are dominated by a handful of gatekeeper platforms that use mergers to kill competition and protect their monopolies. This legislation merely requires that these companies show that their mergers will not expand or reinforce their monopoly power or kill off competitors or potential competitors. Transactions that do not trigger those concerns are not restricted. Earlier this year, the Antitrust Subcommittee received a letter from Consumer Reports advising that legislation is needed to, quote, reaffirm and clarify the longstanding presumption that acquisitions by the largest corporations that already have significant market power are anti-competitive and unlawful, subject to a clear showing they are not, end quote. I could not agree more, and that's exactly what this legislation does. I want to thank my friend, Congressman Jeffries, and Congressman Buck for introducing this important legislation. I encourage my colleagues to support it, and I yield back.
The gentleman yields back. I now recognize the ranking member of the Antitrust Subcommittee, the gentleman from Colorado, Mr. Buck, for his opening statement.
Thank you, Mr. Chair. Google, Amazon, Facebook, and Apple were great American corporate success stories. They're stories of scrappy founders starting a business in garages and college dorm rooms, working tirelessly to build their companies and fend off competitors and acquirers, and ultimately overcoming tremendous odds to reach meteoric success, had immense emotional resonance with the American people, and they were rightly celebrated. I wish that was where the story stopped, but unfortunately it didn't. We now have just a handful of tech titans that dominate our digital sector. They did not reach this status through investment in brilliant engineers and scientists and well-funded R&D programs. They achieved their monopolies through an aggressive merge-to-monopoly strategy. This strategy has meant big tech buys any potential competitive threat and then mothballs their technology. This is not good for our markets, our nation's future competitiveness, or the American consumer. So how have they been able to get away with this? It has all been made possible by a dithering Congress and judges who are all too willing to legislate from the bench. Judge-made doctrines made it possible for Facebook to acquire Instagram and WhatsApp, even though they were identified as competitors by Facebook. Mr. Chair, I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3826, offered by Mr. Nadler of New York. Strike all after the enacting clause.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. In addition to certain technical and conforming revisions, the amendment in the nature of a substitute makes three important changes in the bill. First, the amendment makes clear that to establish the affirmative defense, a defendant must show by clear and convincing evidence that the proposed acquisition does not fall within any of the specific types of mergers described in paragraphs A through D of Section 2B. Second, the amendment clarifies that except as otherwise provided, the Department of Justice, Federal Trade Commission, and the Attorney General of a state have the same enforcement powers, duties, and other authorities under this Act as in certain other relevant antitrust and procedural statutes. Third, To eliminate any doubt, the amendment to Section 5 explicitly provides for the availability of injunctive relief for cases brought by the Department of Justice, the Commission, and the Attorney General of the state. These are brief but important updates to this bill, and I ask my colleagues to support the amendment in the nature of a substitute. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute?
Chairman,
For what purpose does Mr. Jeffrey seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Our antitrust laws are rooted in the fundamental principle that fairness and competition are good for American business and good for American workers. Over the years, antitrust guardrails have provided the path for millions of small businesses and everyday Americans to achieve the middle-class dream and beyond. When companies must compete for consumers, it pushes them to innovate and also allows for new ventures to emerge, filling needs left unmet by dominant legacy platforms. Over the past decade, things have changed, however. A handful of companies have worked to undermine competition by often engaging in the strategy of buying or burying smaller businesses and startups that pose a threat to their dominance in the market. They have built monopolies and eliminated competition through hundreds of mergers and acquisitions. This concentration of market power weakens innovation and entrepreneurship, weakens privacy protections for consumers, and weakens working conditions for employees. If predatory monopoly behavior continues unchecked and competition remains suppressed, economic consequences will be severe. In the past 10 years, the rate of new startups has declined dramatically. So has the number of people working for such companies. Furthermore, the evidence reveals that a lack of competition goes hand in hand with a decline in privacy and data protection for consumers. In fact, the dominance of firms with weak consumer protections has created a kill zone around the market for products that give people tools to protect their privacy online. We need 21st century antitrust laws to keep up with the 21st century innovation economy that is increasingly dominated by companies willing to do whatever is necessary to suffocate competition. H.R. 3826, the Platform Competition and Opportunity Act, would restore competition and entrepreneurship to the innovation economy. The bill requires certain platforms that have engaged in a pattern of buying or burying, for instance, to demonstrate that a proposed acquisition will not eliminate competition or further intensify their concentration of market power. The bill will not prohibit, as the ranking member acknowledged, all mergers and acquisitions. Currently, antitrust law requires the American people, through the FTC, to prove that a proposed acquisition would be unlawful. That places the burden in the wrong place. Instead, the burden should be on dominant platforms who have a market capitalization over $600 billion to show that the proposed acquisition will not further enhance their concentration of market power and violate the law. H.R. 3826 will allow the FTC and other enforcement agencies to identify and address the most problematic types of transactions and to prevent tech giants from detonating competition in the market and undermining the American consumer. I would like to thank the Republican co-lead of this legislation, Ranking Member Ken Buck, for his partnership and tremendous leadership on this effort, as well as the chairs of the full committee, and of course my good friend, the chair of the Antitrust Subcommittee, David Cicilline. It is time to modernize our antitrust laws. It's time to lift up tech entrepreneurs, innovators, and startups. It's time to restore competitive balance in the marketplace and stand up for the American consumer. And I respectfully ask you to support H.R. 3826, and I yield back.
The gentleman yields back. Who seeks recognition? For what purpose does the gentleman from California seek recognition?
I move to strike the last word.
Gentleman is recognized.
You know, there's going to be a series of amendments tonight, and I'm sure they'll all be well thought out. But I think while we're on the underlying bill, the easiest way to put it in perspective what the authors misunderstood here is the fact is that when you start a small company, these companies that are claimed to have been bought and buried, when you start a company like that, and anyone who'd ever watched Shark Tank has seen this, you don't have to do anything more than watch CNBC, which that time of the evening, it's a good thing to watch. And what you discover is that when you start a tech company, you generally, you and your investors have an exit plan. And that exit plan often is, you know exactly who the ideal bidder is for the technology, or at least you know a group of them. This bill will, among other things, likely take these 4 large companies completely out of bidding for these companies, which might mean that there's no one to bid for them, or in fact, that they get less for their exit. It also means that, to a great extent, these companies, which often provide seed capital, substantial seed capital for these companies, will choose not to do it because they won't be able to buy them if they succeed. So when you're taking a look and you're saying, oh, okay, we want we want to take these 4, multi-trillion-dollar companies out of the process of buying and let somebody else buy them or invest in them, what you're really saying is we want to slow the rate of innovation by taking that amount of dollars and investment and assistance out. The reason that we have always had a standard for 100 years for what you, when and how you can buy or invest in a company is that we don't want to have a purchase reduce competition, reduce the consumer's benefit. This bill seeks to change it to where you have to prove your innocence. You have to prove essentially that you're going to make something more competitive in order to have these 4 companies be at the table bidding for good ideas and innovations. I understand the idea of buy and bury, but I will tell you something. In my decades of looking at technology, it is a rare exception that you buy and bury. We all heard about the 100-mile or the 500-mile gasoline engine that got bought and buried multiple times. It's a great old wives' tale. The fact is that great ideas do not stay buried. They almost always get put into production as quickly as possible. Apple has a market cap of over $2 trillion. But Samsung, just one of the Android platform producers, is about $500 billion and doing everything it can to produce more phones faster. It actually produces more phones than Apple, even though its sales are lower. The reality is there is no guarantee of monopoly in any of these companies, and certainly not in one of the companies here, which is Apple. And so when you look at this, I hope you will take a good look and say, do you really want to take them out of the bidding? And any and all of you that have tech companies, if you don't figure it out tonight, because it may be a little late to call unless you've got a tech company in Alaska, the fact is that if you call any of these small businesses and say, were you thinking of your exit strategy including Apple or Microsoft or Google? And they'd say, absolutely, because I've seen them pay billions of dollars for companies that are in some cases not yet profitable, but have great opportunity. That's all I have to say. I thank the gentleman. I yield back.
The gentleman yields back. For what purpose does Ms. Ross seek recognition?
Mr. Chairman, I have an amendment.
The clerk will report the amendment.
Where's the amendment? Should we suspend?
Okay,
We'll suspend for a moment and then
we'll come back to Ms. Ross. What purpose does Mr. Gates seek recognition? Gentleman's recognized.
Thank you, Mr. Chairman. I'm proud to join many of my colleagues from the subcommittee in introducing this legislation. And many of the things my friend from California said are true regarding taking the 4 major platforms out of the bidding for some startups. But innovation is not of value just for the sake of innovation. It has to be able to be utilized and deployed. And the value proposition on innovation is that it can make people's lives better. And the investigation that we conducted showed time and again that oftentimes the very first thing that the 4 major platforms would contemplate in order to deal with a competitor was acquisition. They would say so brazenly, not with no disregard for the impact on the marketplace, but with a keen understanding that they would harm the marketplace with such an acquisition. The legislation does not require someone to prove their innocence. It does require them to prove by clear and convincing evidence that they're not harming the marketplace. So they don't have to enhance the marketplace. They just have to prove by that standard that they aren't harming it. And much of the critique of this legislative package has been that the legislative efforts require this excessive entanglement of the government in, day out decisions, whether it's the design of some sort of a la carte system to deal with portability or interoperability. And those objections would fall flat relative to this bill because it has a prophylactic effect. If the 4 major platforms understand that they are facing a different standard and that they are going to have to come up with a different amount of proof, then they are less likely to engage in that conduct in the first place. And so there's less of it to police and less concern that we're wrapping the axle of government, or we're wrapping government around the axle of this particular industry. I would encourage my colleagues to support the legislation. I yield back.
The gentleman yields back. For what purpose does Mr. Lou seek recognition?
I move to strike the last word.
Gentleman's recognized.
Thank you, Chairman Adler. Let me first of all thank Congressman Jeffries for your hard work on this issue. I agree with you that large companies buying up small companies to stifle competition is a bad thing, and we need to address this issue. It is a nuanced, complicated issue. I commend you for taking it on. I do have 2 concerns. Because of the way that this subcommittee investigation happened, the subcommittee picked 4 companies to investigate. But because the subcommittee did not investigate Microsoft, which is competing against Apple and competing against Google, it's not now covered by this legislation. So if we think it's bad for Apple to buy up companies to help its own operating system, we're letting Microsoft do this, even though Microsoft's operating system is twice the size of Apple's iOS operating system. So before these bills get to the floor, I just would urge you again to look at the definition of covered platform, because you can't just sort of exclude other companies in the exact same space competing with these same companies where they actually have more dominant products. I mean, the Microsoft operating system is just more dominant than iOS operating system. And then we're treating these 2 companies disparately. And the second concern, before this bill hits the floor, if you would look at, is, I met with a lot of entrepreneurs and know entrepreneurs, as well as startup employees and investors. And all of them would love to be the next Google or Apple. But it's also clear that they understand that they, might not become the next Google or Apple, and they will be thrilled to be brought out. The way that this legislation works, it could have the unintended consequence of basically trapping these companies with sort of the stark reality of either they've got to make it big, or they're eventually going to get stuck and fail because they have no exit strategy. They can't be purchased. And I think that could stifle innovation in our tech sector. And if you would look at maybe having some sort of floor that says, okay, for certain size companies, we would not apply this bill to. Because I think there would be a difference, for example, between Apple buying a small startup of 15 people versus, let's say, Google buying Twitter. And I think you should look at making that kind of distinction before this bill gets to the floor. Thank you for taking this very big challenge on, and I yield back.
The gentleman yields back. Ms. Parks is recognized. For what purpose do you seek recognition?
I move to strike the last word.
The gentlelady is recognized.
Thank you, Mr. Chairman. I'm not a legal scholar, but sometimes I think it's probably good to have not just attorneys on this committee, but a common sense people, just because the laws are written for ordinary people to be able to understand. Otherwise, things get so complicated unless you are very wealthy and can afford very expensive attorneys. The system is stacked against you. But it's really what surprised me, being a state legislator, and I was kind of joking, if we can waive the law school, I probably could pass the bar when I was state senator. I probably, after this committee, I definitely could do it, which actually it's a big protection, is all this licensing from all of this very expensive academia, making a lot of money on that. And most of them now going to create more barriers to a lot of professions. But so I'm looking at things very simply. I always believe American system is built on the presumption of innocence, and burden of proof always have to be on the side. Who is accusing? Or the government. It's never should be someone to prove that I am not causing harm. You have to prove that I am, that I caused the harm. So I think it was very surprising and appalling to me. In so many cases now, we become the society, you are guilty until you prove you are innocent. And it's a very dangerous precedent we're setting up with all of these laws like that. So I think it's a very serious discussions. And I don't really, care if it's small or bigger companies. Instead of actually providing preferential treatment to some of these larger companies, we a lot of times do, with a lot of loopholes in our law, we also shouldn't pick losers and winners and come after some of them. I think that's the wrong way to do it. It should apply equally to all of the stakeholders in all of the markets. But I think it's a very dangerous precedent to actually move the burden of proof from the government to these companies to prove that they're innocent and they're not causing any harm. And I do not think we as legislators should be legislating laws like that, because our system is based, this is what Americans' freedom and the beauty of American system, that you actually have a protection from the government. And we have a different standards what government who accusing you have to prove. But ultimately, whoever is accusing you of something, they have to do their work to prove that you did something wrong. If they cannot prove it wrong, too bad. Then you are innocent. And I'm really concerned with moving the standard. And the whole system is moving in that direction. It's very disturbing for me to see that. And I hope, maybe we can fix it with some amendments, look at other details, but this thing sets a very dangerous precedent, and I would not be able to support this bill.
Will the gentlelady yield?
Yes, I yield.
I just would mention that this burden shifting is well-established practice in antitrust law, in particularly concentrated markets, and it's been very effective. So it has worked, in part because the moving party has most information with respect to the transaction. So it has been an effective tool in terms of preventing deeper and deeper concentration in very concentrated.
So if you believe that if there's already there, so why do you need this legislation?
Well, no, I said that practice of burden shifting has been used in antitrust.
But you try to put it in the code, in this. You codified. If you believe that practice already exists, because this is codified specifically in the law, what I have to do to be able to prove that. It seems to me it's really put a standard that I haven't seen it. It seems like it exists in in our current environment, but this is actually put it in the law that burden of proof it would be on these companies.
For these covered platforms in the highly concentrated markets that we.
But don't you believe it set up a kind of a precedent, dangerous precedent in the law to see who actually has to prove that?
I mean, I don't actually think it's a dangerous precedent. I think it's an effective tool to ensure that these markets, which are highly concentrated, don't become more highly concentrated, don't become stronger gatekeepers, don't have higher market concentration that can exclude and crush competitors and undermine competition.
Well, I agree with you, but actually government has to prove that the harm is created. So
Yeah,
I'm not
and
agreeing.
that's
They
what
create a
fine.
lot of harmful things, but the government should actually make that determination and create that you are guilty. And until the government proves that you're guilty, you have to be innocent. And I think that's an important part of our system. And I yield back.
The gentlelady yield back. For what reason does the gentlelady from North Carolina seek recognition?
Thank you, Mr. Chairman. I now have an amendment.
The clerk will please report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3826, offered by Ms. Ross of North Carolina.
Gentlelady is recognized to explain her amendment.
Thank you, Mr. Chairman. And this amendment addresses some of the concerns that have been raised about tech companies that are startups that really don't intend to get fully fleshed out. My district is part of the Research Triangle in North Carolina and has a proud history of innovation and is part of the innovation economy. We're home to top-tier research institutions, a highly skilled workforce, and cutting-edge companies. We also have a large population of innovators and entrepreneurs, and many of these people start small businesses they have no desire to operate in the long term. Instead, their ultimate goal, as we've heard, is to sell their businesses so they can move on to the next product, the next innovation. My amendment allows these small business owners to continue to do what they do best, innovate. It adds a floor so that transactions below $50 million are exempt from the bill. With this amendment, without the amendment, innovators could be disincentivized from starting their own businesses, and small businesses might not be able to attract the financing they need to bring an idea to fruition. For this reason, I urge my colleagues to support our small businesses, our innovators, our serial entrepreneurs, and vote yes for this amendment. And I yield back.
Will the gentlelady yield?
Yes.
I
yield.
thank the gentlelady for the, I thank you for this excellent amendment and for working with the staff of the subcommittee and with the lead sponsor, Mr. Jeffries. I think it's very important to protect the innovators you described. I urge everyone to support this amendment. And with that, I yield back.
Thank you, Mr. Chairman. I yield back.
The gentlelady yields back. Mr. Gates, for what purpose do you seek recognition?
To strike the last word on the
The
amendment.
gentleman is recognized.
I would ask the chair to indulge me in a colloquy. Would the effect of the amendment, in the opinion of the chair, allow these four major tech platforms to catch and kill anything under $50 million?
I think the investigation really showed that the transactions that were of great concern are transactions above that amount. These are typically in the billions of dollars.
Mr. Chairman, I recall observing some evidence, I can't cite at the moment, but that oftentimes it was just when a new technology or a new business was showing promise and maybe hadn't reached the $50 million threshold that they would be most susceptible to the anti-competitive practice.
Yeah, I would say to the gentleman, the Clayton Act remains in effect, and so that those standards still must be applied with respect to merger transactions.
But isn't the whole premise of this legislation that the Clayton Act is insufficient when dealing with these four behemoths?
Yeah, I think the amendment strikes the right balance, that it protects some of these early stage innovators that I think Ms. Ross spoke about in offering the amendment. And again, I think the bulk of the harm comes in much larger transactions.
And my concern is that now we've created, if this amendment were to be adopted to the bill, we will have created a system where if you're big enough, you can't be caught and killed, but if you're smaller, you can. And it would seemingly just create this massive loophole in the legislation. I don't know, I'm a bit caught off guard by the amendment and somewhat surprised the chair's support.
I would just say that we did look at all the transactions of the parties that were the subject of the investigation, and none that fell below that amount were of any concern to anyone who reviewed them.
Thank the
Thank the
chair's
gentleman for
indulgence.
yielding.
I yield back.
Gentleman yields back. Ms. McBath? For what reason does the gentlelady from Georgia seek recognition?
Thank you, Mr. Chairman. And I am really pleased to be able to support Congresswoman Ross's amendment and Congressman Jeffries' legislation. I think this amendment, as you've stated, really kind of strengthens the ultimate goal of this legislation. It definitely promotes competition and innovation. And throughout our discussion today, as we've been listening all day, there's been definitely some disagreement about some of the aspects of these bills. But I think that we can all agree that competition and innovation definitely go hand in hand. And, when one company has all the power, even the most creative new approach can have a hard time kind of breaking through to new customers, and consumers end up being you just saddled with, limited kinds of choices. But when there's healthy competition, this is what we've been doing all day long. Companies win over their customers by giving them the best products and services and improving consumer choices for them. So they respond to competitors by constantly seeking to improve those products and those services, and not simply just buying out the competition. And at the same time, innovators and consumers alike, they all benefit from some of these acquisitions. So I'm pleased to support this amendment and making sure that small innovators have options to be able to reap the rewards of all the work that they put in. And whether by licensing, their software or selling their businesses, whatever they choose to do, selling their businesses to another company in a way that does not harm overall competition. I'm really excited to support this legislation through this amendment, and I urge all my colleagues to support this amendment, and I yield back the balance of my time.
The gentleman yields back.
Mr. Chairman?
To Jordan. Yeah, for what purpose does the gentleman seek recognition?
Let's just strike the last word. Mr.
Gentleman is recognized.
I'm just trying to understand. So do we have 3 standards now? If you're not a covered platform and you want to, some kind of merger, some kind of acquisition, the burden's on the government to show that would be anti-competitive, or it proceeds. If you are a covered platform, the burden is on you, as Ms. Sparks pointed out with her comments, to show that the merger would not harm competition. And then we have a third category. If you are a covered platform, but you're acquiring someone below 50 million in market cap or market value, whatever, then it's back to the original standard. So, yes. That's going to work well, right? 3 standards. That's going to work great, I think. I'll yield to the gentleman from. I just want to make sure I understand it. I'll yield to the gentleman from Arizona.
I thank the gentleman for yielding. As I read the amendment, I think it's interesting. But if I was counsel to an innovator, I'd be telling them that we're going to be looking to split this company. We're going to be splitting this company, which we can do under most state laws that I'm familiar with, and we would never be hitting the 50 million mark. We're going to be sitting somewhere between $25 and $45 million every time. And I do know innovators, and this is what they do. They build up the company. While they're building their company, they're already in negotiations to sell, to be acquired. And what I would be doing, advising my client, is let's split, make sure that we don't have to go through this onerous FTC requirement, and away we go. I yield back to the gentleman from Ohio.
Sorry.
Would the gentleman further yield?
Yield to the gentleman from California.
Not only
California
is
is recognized.
Thank you. Not only is the gentleman accurate that you can slice and dice this, but as much as I agree with the gentlelady that the more companies we carve out of this, the less bad this idea is. But let's go through a couple of other simple examples. You had dollars. How about if it's $1 billion, but it's simply a patent portfolio of a university? Would that be allowed? How about if it's a whole new area not currently held by that company? Berkshire Hathaway can bid for it, but Apple can't. So as much as I will be voting for your amendment, as much as I agree to the amendment shows the vulnerability of the bill, because we can go through example after example, and each one will say, well, wait a second, in that case, you ought to allow it. In this case, you ought to allow it. Pretty soon, what you realize is an awful lot of situations in which this new standard just doesn't make any sense. And it doesn't make any sense because for so long we've always asked, is it anti-competitive? We can prohibit it. If in fact it's not anti-competitive, why not let them do it? It might be a good idea. You know, I know you held hearings and I appreciate that, but I think the gentlelady's amendment, which you've endorsed, which does make sense, is the beginning of half a dozen equally good ideas that you should be accepting. I yield back.
Well, yeah, and the point is, where does it end? What's next? Do we go from 3 to 4 to 5 standards, 6 standards? Where does it end? And we know that the folks making the decision at the FTC, certainly the majority there now, the chairman, the former acting chairman, have this leftward bent big time. They want to do all kinds of things with antitrust law. They've told that. They've said that. I don't know. I just think this just adds that much more concern to what's happening here. With that, I would yield back, Mr. Chairman.
Gentleman yields back. Mr. Jones, for what purpose do you seek recognition?
I move to strike the last word.
The gentleman is recognized.
Well, let me begin by thanking you, Mr. Chairman, and your staff. For over 2 years, you have presided with courage and conviction over one of the most thorough and bipartisan, as we've seen today, legislative investigations in a generation. And now, alongside the ranking member, you have led a legislative agenda that will truly take on big tech. I want to thank also Representative Jeffries and Ranking Member Buck for introducing the courageous legislation that is this bill to prevent big tech from buying its way to even more power over the American people. I'm proud to co-sponsor this bill with you. And of course, thanks to all of my colleagues and their staff for sticking with this for so long today. And I do hope that we can complete this at a godly hour, so to speak. The Platform Competition and Opportunity Act strikes at the heart of how the big tech companies have become so powerful, buying up and often killing off their potential competitors or locking down the assets that they need to entrench their dominance. Google captured the online advertising market by acquiring DoubleClick and a host of other advertising technology firms. Amazon bought over 100 companies in the last 2 decades, including rivals like Zappos, Diapers.com, and Whole Foods, consolidating its dominance as the, quote, everything store. Facebook's purchases of Instagram and WhatsApp left us with 3 major social networking options: Facebook, Facebook, and Facebook. All told, in the last decade, the dominant platforms made over 400 acquisitions. Yet antitrust enforcers did not block even one of them for being anti-competitive, not a single one. And why not? In part because the tech companies assured the commission and the courts that bigger was somehow better, that letting the biggest corporations kill their competitors and consolidate their power would work out for the best. By now, we know the truth. It has not. Of course, bigger is better if you're a big tech billionaire like Jeff Bezos or Mark Zuckerberg, and all you care about are your corporate profits. But for the rest of us, and I hope every member of this committee, though I have been disappointed by much of today's discussion on these bills, this unchecked dominance is much worse. Corporate consolidation drives down worker pay, increases layoffs, reduces opportunity for small businesses, and denies all of us meaningful choices online. This bill calls big tech's bluff. If bigger is really better, they should have to prove it before they can buy their way to more market power. And if they can't, by clear and convincing evidence, prove that their acquisitions won't harm competition, then maybe, just maybe, some of the richest, most powerful countries, or companies rather, in human history don't need to get any better or bigger. So it's time to take on these anti-competitive acquisitions that have created this crisis of consolidation, and to ensure that once we break up big tech, these companies can't just consolidate all over again. I sincerely hope that all of us will support this essential legislation. Thank you, and I yield back the balance of my time.
The gentleman yields back. Who seeks recognition? I believe Mr. Nagoose. Oh, I'm sorry. Yeah. Oh, sorry, Ms. Jackson Lee. I apologize. For what purpose do you seek recognition?
Mr. Chairman, I ask to strike the last word.
The gentlelady is recognized.
I asked my colleagues, interesting that we would go down memory lane in this high-tech moment of innovation, but I asked to do so as I thank Mr. Jeffries for his thoughtful legislation based upon the long years of investigation, and of course with the committee, Mr. Cicilline and other members who are on this subcommittee. Glad that we in the full committee has an opportunity to begin the journey. This is only the beginning. These bills have to go to the floor. There'll be much intensity and of course to the Senate, but they are worthy of our consideration because this has been going on for a very long time. Memory lane will have us look at the banking industry and what we banked 20, 30 years ago and where we're banking today. Industry has been depleted by bigger and bigger buying smaller, and the competition and opportunities for the consumer have gotten worse. Or maybe we should take a memory lane journey down the aviation industry and watch as what was many years ago a multitude of aviation opportunities, now where airlines are shutting off 1,000 flights and telling consumers, do the best you can. Maybe take your own flight, take your wings. And then, of course, the auto industry, that again, bigger is better, and we saw the diversity and the choices of autos going down, down, down. So I think this is vital in this new tech industry with giants that certainly have made an enormous impact economically on this capitalistic society. But these dominant platforms, again, have acquired hundreds of companies, and as well, the fact of this bill prohibiting acquisitions of competitive threats by dominant platforms, as well as acquisitions that expand or entrench the market power of online platforms, is important. And I think it's important that there is some framework that includes the DOJ and state attorney generals. Many of these incidences occur with state entities. In many notable cases, these firms acquired actual or potential rivals to neutralize competitive threats or further expand their dominance. Innovation is extremely important, and I think Ms. Ross has a very important contribution to this particular legislation, because in the midst of those companies under 50 million are many minorities and women and young people who really did want to have a startup, be innovative, and then go on to the next. That's okay. But in the instance of this legislation, there are firewalls. This doesn't stop large companies from achieving or attaining a willing purchased entity. It provides a firewall of determining whether this does not compete with the covered platform, represents potential competition, enhances the covered platform's market position, and enhance the covered platform's ability to maintain its market position. I think innovation is extremely important. I think the growth of the interests of women and minorities in this business is extremely important. But as has been noted, name brands have gone. Maybe they could have survived. Not that this is completely parallel, but it saddens me to hear that a paper down the road in Maryland that suffered major tragedy of shootings on site are being consumed by private equity. And guess what? That little paper that saw so many of their employees killed are getting employees laid off as the private equity purchased them. Same parallel with these big dominant platforms that would go after some important names, and all of a sudden you see the shutdown of the entity and the loss of jobs. So I think this is long overdue, and the killer acquisitions should stop, innovation should go up, and these dominant platforms need to make their case that these are not threats and that they're not there to decrease employment, but actually to improve and enhance the American economy. So I support the gentleman's legislation underlying amendment. Thank him for his leadership, as my colleagues as well, to support this legislation. I yield back.
The gentlelady yields back. Who seeks recognition? Ms. Lofgren?
Thank you, Mr. Chairman. I seek to strike the last word.
The gentlelady is recognized.
First, I want to thank Mr. Jeffries because he has identified what I think is a serious problem, which, looking at some of the mergers and acquisitions that have happened in this space, of course, hindsight's 20/20, but clearly there were some mergers and some acquisitions that should not have been approved. And I do agree that we need a change in the standards moving forward to prevent that kind of situation in the future. Having said that, I think while the problem has been identified, the proposed solution is a bit overbroad. I heard with interest Congresswoman Spartz talking about proving that you're going to not compete. Actually, that's not what the standard in the bill is. I think really an honest reading of this is it would prevent any merger or acquisition on the tech companies that are the object. Because if you look at page 2, line 3, the acquired stock do not compete with the covered platform or covered platform operator for the provision of any product of service. Well, if you look at the broad range of what's being offered, that's almost everything. And it's not just actual competition, it's potential competition to the covered platform, and that includes something, potential competition for the sale or provision of any product or services, which includes competition for a user's attention. So I think really this is a prohibition, would result in a prohibition of mergers and acquisitions. Well, that could be problematic in some cases. We've talked about the model of entrepreneurs starting a company with the hopes, I mean, there's really 3 things that can happen. You can go bankrupt, you can get acquired, or you can go public. And it's very hard to go public because you need a certain kind of market capitalization and some oomph. And so it's not always wrong that there's an acquisition, although it can be wrong. And so I think the idea that the remedy is to prohibit acquisitions entirely by these platforms is not the right remedy. I'd note that there are reasons why a company can acquire another company that have nothing to do with competition. For example, Apple acquired a voice recognition company, but the reason why they acquired it was to get the technology and the hotshot employees who helped them build the Siri app on the iPhone. That wasn't to get market power, that was to create a new technology, and yet the acquisition for talent and technology would also be precluded. I'll note that Senator Klobuchar has introduced a bill on the other side of the building that would change the language in the Clayton Act to make it easier to sustain challenges against anti-competitive mergers. She, and I'm not an expert on her bill, but the standard she would set would put the burden on the acquiring company to establish by a preponderance of the evidence that the transaction will not create an appreciable risk of materially lessening competition. I think that that is something that we ought to be looking at because it's not just harm to consumer. We do want to foster competition. Finally, I will say that once again, we've limited this to just a few of the tech platforms who could not merge or acquire at all. But that doesn't preclude foreign competitors from coming into the United States and buying up these very same companies. And I think the potential detriment to our national competitiveness is something that may have been overlooked in this case. So I'm hoping that we can do some refinements on this bill. I agree that this is very much a legitimate issue for us to pursue, and I'm hopeful that we can refine the approach, as I think the measure before us is overbroad. And with that, I see my time has expired, and I yield back, Mr. Chairman.
Gentlelady yields back. For what purpose does Ms. Jayapal seek recognition?
Move to strike the last word, Mr. Chairman.
Gentlelady is recognized.
Thank you, Mr. Chairman. I want to thank you for holding this important markup, and I want to thank Chairman Cicilline and Ranking Member Buck for all of the work that they have done in our subcommittee to get us to this point. We've gone through a 16-month investigation, reviewed nearly 1.3 million documents collected as part of that investigation, consulted with 60 experts, and held 10 hearings, including 4 hearings on proposals to restore competition online and strengthen our nation's antitrust laws. The bills that we're marking up today are a direct result of that work and the 450-page report that this committee approved in April of this year. What we uncovered was clear and damning. These unregulated tech monopolies have grown too big and too powerful to care. Yet, they are the gatekeepers controlling access to markets for sellers and buyers. These giants have the power to pick winners and losers, the power to set the rules for everyone else, while they break them to benefit their own self-interests. So the bills that we're marking up today restore fairness and competition for consumers and small businesses, ensure our democracy and innovation continue to thrive. And I'm grateful to my colleague, Congressman Jeffries, for proposing this bill, the Platform Competition and Opportunity Act, which would prevent dominant online platforms from buying competitors or potential competitors in order to expand their market power. Last July, I asked Mark Zuckerberg about this very issue. Through our investigation, we looked at Facebook's emails and interviewed its competitors and found a clear record of Facebook's attempts to copy, buy, or kill its competitors. In one instance, we looked at emails from March of 2012, in which Mr. Zuckerberg suggested by email to his management team that moving faster and copying other apps could, quote, prevent our competitors from getting footholds. Sheryl Sandberg responded that, quote, it's better to do more and move faster, especially if that means you don't have competitors build products that take some of our users. Facebook's product management director added, quote, I would love to be far more aggressive and nimble in copying competitors. One key example is Instagram and Facebook Camera. In this instance, Mr. Zuckerberg threatened Instagram's founder, Kevin Systrom, telling Mr. Systrom that Facebook was, quote, developing our own photo strategy. So how we engage now will also determine how much we're partners versus competitors down the line, end quote. Instagram's founder seemed to think it was a threat. He confided in an investor at the time that he feared Mr. Zuckerberg would go into, quote, destroy mode if he didn't sell Instagram to Facebook. Bottom line, Facebook copied a successful product, went to the company it identified as a threat, and told them that if Facebook couldn't buy that, there would be consequences. In the nearly 2 decades since Facebook's founding, it has grown into a corporate giant that isn't simply trying to help people connect with friends and family. It has morphed into a monopoly power that harvests and monetizes our data for its own profit, for the purposes of spying on and destroying its rivals. Facebook's practices have stifled competition and made it impossible for new companies to prosper. Under Mr. Jeffries' bill, Facebook's predatory practices would be prohibited. This is a necessary step to protect our democracy and ensure that small businesses and startups can thrive. I urge my colleagues to support this bill, and I yield back.
Gentlelady yields back. For what purpose does Mr. Nagu seek recognition?
Move to strike the last word, Mr.
Gentleman
Chairman.
is recognized.
Thank you, Mr. Chairman. First and foremost, I again want to thank Chairman Cicilline, the chairman of the subcommittee, and of course, the ranking member for their leadership, and to Chairman Jeffries for bringing forward this very important bill for the various reasons that my colleague from Washington, Representative Jayapal so eloquently stated the rationale and the reasoning for this particular piece of legislation. And I'm grateful again to Chairman Jeffries and to Ranking Member Buck for leading the effort. I wonder, and I assume that Chairman Cicilline would be available for a brief colloquy with respect to this particular amendment. I have some trepidation about the amendment, and so would benefit from perhaps a deeper explanation as to the rationale for the number that is purportedly to be used in terms of the limitation and the $50 million number. And I guess just by way of background, first I would say it's unclear to me as to whether or not this language would preclude a company from structuring a transaction in a way that ultimately escapes the scrutiny that this bill attempts to impose, along the lines of what Representative Biggs, I believe, was referencing. You could envision a scenario in which an asset purchase agreement is structured so that the $50 million number is not, that threshold isn't crossed. And then more broadly, I guess I would just say it was my understanding that while the most problematic transactions that our committee examined and I think found significant evidence to indicate were deeply problematic and warranted the scrutiny of regulators, in particular the transactions with respect to Facebook that Representative Jayapal mentioned. I think there are other transactions that would certainly fall within the $50 million range. And so it's unclear to me why that number, which appears to be somewhat arbitrary, would have the impact that that folks are suggesting. I'm certainly open to tightening the competition language, and I think Representative Lofgren made an important point in that regard, and so that would be a discussion that I'm open to having. But I have, as I said, some trepidation about imposing a financial condition in this particular context. And if the chairman would like to respond to any of that, welcome his input.
Mr. Chairman, I'm happy to answer Mr. Negus's questions, if that's okay. Mr. Negus?
Yes, of course. Yield, Ms. Ross.
Yes. So in negotiating the amount, we looked at the amounts of a lot of the transactions that had gone through and had learned that the FTC doesn't give that much scrutiny to transactions that are under about $35 million. And that there aren't that many more transactions that go up to $50 million. But, we're going to have this, hopefully this bill will be the law will be in effect for a period of time. So that $15 million margin seemed to be appropriate so that we wouldn't get into the problematic ones and we would be closer to the ones that didn't receive as much scrutiny or concern from the FTC. And that was the rationale for the amount.
Thank you. And that's helpful context. And I should say, I appreciate your efforts, Ms. Ross, and of course the efforts of other members to provide the kind of robust debate that we're having in terms of how to improve these bills. So with that, I don't know if my time is expired, but I'll yield back the balance of my time, Mr. Chairman.
Gentleman yields back. For what purpose does Mr. Issa seek recognition?
To move to strike the last word on this amendment.
Gentleman is recognized.
Thank you. I want to point out a couple of things that trouble me on this bill that I know we're working on the underlying amendment, but there are some requirements here that boggle the mind, and I wondered how they got in here. These prohibitions on the companies, for example, the role of data on page 3. Covered platform or covered platform operator is not allowed to make an acquisition to maintain a market position. And presumably we would, this 50 million would strike that. So, one of the challenges is it also the role of data. That you can't do this if you're acquiring data. Now, I've made a couple of dozen acquisitions over my years, and there was always data that came with every acquisition. So by definition, nobody could meet that. And I'm presuming that if it's under 50 million, then we don't mind. But that's one of the real questions here. The gentlelady from Seattle was nicely talking about the Facebook, and she described an evil, rotten, terrible company headed by a person who was inherently evil who had to be stopped. And that may or may not be true, but what I found was that exactly what King Henry VIII did that we prohibit in our Constitution is what I think we're doing here tonight. And I just want to make it this point one more time. We have tried, Mr. Cicilline has apparently for 2 years held court, and he has tried and convicted 4 companies of being monopolies, of being trust, of being appropriate to put a consent decree on. And these bills, one after another, fashioned with the help of the Federal Trade Commission detailees and others, in fact, are nothing but bills that, in fact, would do much, maybe more than what a normal consent decree would do. And I have to question, and I will question it now, and I will question it on the floor, and I suspect we will question it in the courts, whether or not this is, in fact, a trial by the House sent to the Senate to convict 4 companies without a trial that they get to defend themselves at, and give them what would be effectively an antitrust decision by us. And I can't find, when I find their limitations in this bill, and I could go through them for another half hour and find more of them, I can't find that we won't do that. And so although I will be voting for the gentlelady's amendment because it makes it less bad, I must admit that whether they circumvent it or not, we are still going to have to ask, on what basis did we try people, companies, without their ability to offer a defense, without the ability to go through? Why are we making accusations about basically criminal accusations, or certainly accusations that would be unfair competition? But they're not here to defend themselves. We're only hearing one side of somebody's story, and we're making a decision to when they can do what in the future because we've written their consent decree. Except, of course, there's no consent, there's no trial, there's no defense, and we're figuring that we know better, but we're going to send it to the Federal Trade Commission, and they can continue to execute the consent decree. That's really where we are here tonight. And I know we're not going to resolve this before 4 or 5 or 6 in the morning when we get through all the bills, but I cannot find that we have gotten past that fundamental question that we, in fact, are violating the constitutional prohibition on penalizing people without a trial, penalizing people by passing a law that finds them guilty without due process. They have not been given due process. They certainly have not been given their day in court. And I will vote for this amendment, but I will be voting against the underlying bill, and I yield back.
Gentleman yields back. Who seeks recognition? Mr. Jeffries. For what purpose does Mr. Jeffries seek recognition?
I move to strike the last word.
Gentleman is recognized.
I just wanted to thank the distinguished gentlelady from North Carolina for this amendment, which I think is a step in the right direction, trying to address the concern that many of my colleagues have articulated related to the potential inability of tech entrepreneurs and small startup innovators to be able to realize their dream of being able to grow a modest company and then sell it. And I certainly don't think it's the intent of the authors of this legislation to squelch that dream. Although I do ask the question in the broader context of this country and the framers of the Constitution, who, of course, gave this Congress the power to create a robust intellectual property system, in the words of the framers in Article 1, Section 8, Clause 8, to promote the progress of science and useful arts. So the words of the framers. And I don't think that the framers were intending to incentivize people, incentivize investors and entrepreneurs to dream big so they can sell a modest company. I think they were incentivizing investors and entrepreneurs and innovators perhaps to dream big so they could change the world, dream big so that they could create an innovative product, build companies that would lead the world in a wide variety of things. And I think that is the fundamental problem that we're trying to address, that because of these tech giants, that ability for entrepreneurs and innovators to dream big and grow companies that would change the world, and that's been the American journey, that has been crushed in many instances because of these dominant tech giants who have a clear strategy of copy, acquire, or kill. And I don't want to compare them to organized crime figures, but there was a famous saying in The Godfather, I'm going to give you an offer that you can't refuse. And a 2-year investigation revealed that that in fact was the case. And I've heard a lot about due process concerns. I wasn't on the Antitrust Subcommittee. Chairman Cicilline did a tremendous job. I think the 4 CEOs testified before this very Congress. And they were very clear about the terms of their appearance, and they weren't going to appear in person, and this is how long it was going to last, and we're going to provide these documents. That kind of sounds like due process to me. And they've got an army of lawyers at their disposal. And so this particular piece of legislation, and I thank Ken Buck, who's been extraordinary as a leader in this area, it's not cutting off the ability for a merger or acquisition to take place. It's addressing the burden question. And I think the fundamental question here is when you've got tech giants, when you've got big tech, many of whom have engaged in predatory behavior, hundreds of acquisitions, a small handful of them have ever been scrutinized. Not a single one was challenged in court by the FTC. Why? Because they did not have the vehicle to do it statutorily. Not a single one. Hundreds of mergers and acquisitions, many of which have been discussed, Instagram, WhatsApp, others, not a single one challenged because the legal landscape didn't exist. And it's the prerogative of this Congress to perhaps say, if we've got a choice, should the American people bear the burden of proof, or should a multi-trillion-dollar company that has engaged in anti-competitive behavior, predatory behavior, bear the burden of proof?
Will the gentleman yield for a question?
Yes, sir.
Is the gentleman concerned that if this amendment were to pass, that companies might break up and it undermine the intent of the bill?
I'm not. And I'm not because I think that there will always be entities that endeavor to engage in behavior to evade laws that are being put into place by the Congress. But I think this strikes a reasonable balance because the overwhelming majority of concern, as uncovered by the investigation from David Cicilline and Representative Buck, is that the transactions that are problematic are much higher in volume in terms of the scope and scale of the acquisition.
The gentleman's time has expired. For what purpose does Mr. Roy seek recognition?
Move to strike last word.
Gentleman is recognized.
I'll talk a little bit more about the bill in a minute when I have an amendment to offer. But with respect to the amendment offered by the gentlelady from North Carolina, I too represent an area with a lot of high-tech interest in Austin, Texas, San Antonio, Texas. And I understand the desire to carve out small startups, but I'm troubled by the fact that we have to carve out anyone in the first place, right? I mean, there's a reason for seeking the carve out, and it's because of a significant burden shift. And 51 million, 55 million, 100 million. I understand we set an arbitrary number to just sort of basically represent a smaller business in this case. And I understand there was a record and that I think this is an attempt to reflect the record with respect to trying to preserve small businesses in this case. But this gets to the heart for me of when we had the debate earlier this morning with the gentlelady from California, lowering it to $250 billion, but then that doesn't really include everybody. And that this whole framework is built on the notion of the 600 billion and the 500 million user. I mean, it seems like to me, we are grasping at straws to try to define something that's going to be shifting sand because we're not defining the behavior and we're not focusing on the behavior, the monopolistic behavior. We're focusing on trying to define entities that fit within what we're currently defining as the behavior. And that to me is the problem. So we're going to come back on the back end of this. We're going to go, well, we're going to have to amend this because the 50 million isn't right. We're going to have to amend the 600 billion or amend the 250 billion. We're going to have to keep tweaking this to try to chase the market. And that I think is not getting to what we want to get at. And I'll have more in a minute with an amendment that I'm going to offer that is trying to get at the actual monopolistic behavior, maybe not perfectly, and we'll talk about that in a little bit. But my concern about the amendment offered by the gentlelady is that we're carving out something because it needs to be carved out because we've set this standard by reversing the burden in a way that I think is really concerning and having companies having to come to say, "Mother, may I?" And I mean, do I care that currently Google, Facebook, and these large companies have to come say, "Mother, may I?" No, I'm not particularly bothered by that personally at the moment, but that's going to change. Those sands are going to shift. There's going to be more companies that's going to fall into that. And we're going to go down that road. That's my concern. That's my unease with this. It's why I will likely oppose the amendment.
Does the gentleman yield back? The gentleman yields back. For what purpose does Ms. Swartz seek recognition?
I move to strike the last word.
Gentlelady's recognized.
Well, thank you. I want to, as I mentioned before, I don't like this bill, but I think that amendment actually even make it worse, and I'll tell you why. As a gentleman from New York talking about the dream, it's actually, as a smaller company, it actually limits my dream because now it puts me in a position I'm thinking, okay, should I try to bail out and sell, or maybe I should grow company? Or like, okay, if I grow more than 50 million, I'm going to be in position that the choices who wants to buy me are going to be much smaller. You also put me in a position where negotiation power give this large big companies to say, hey, I'm not going to pay you 55 or 65 because I'll pay you 49.9. Otherwise, I'm going to be in all this jurisdiction that I will not want you. So it puts me in a real tough position too. And actually, maybe otherwise I would be grown and become a 100 million company or 100 billion company and actually create a competition to these large big tech companies. But I'm now thinking, no, that might be actually much worse for me. So I think it actually puts a lot of entrepreneurs in smaller company in much worse situation. And create the environment right now where you create a limit at how much I could be grow and how competitive, because ultimately we want to have an environment that anyone can decide either to sell the company, either to grow it and become a multi-billion-dollar company, and I should have the choice and not to be limited because there are some subjective rules that are setting up and limited my choice. So I think it actually will hurt some entrepreneurs in smaller companies to create wealth and become more competitive in this market and allow the bigger companies have more negotiation power on the market. And I truly believe this amendment make this bill that I do not like already, make it even worse. And I think my colleagues should not support this bill. I yield back.
The gentlelady yields back.
Who was asking?
Was the
Already yield back. I don't know.
someone trying to?
Yeah, Mr. Chairman, I move to strike the last word on the.
Okay, the gentleman. For what purpose is the gentleman?
This would be on the amendment.
The gentleman has already spoken on this amendment.
Well, point of order, Mr. Line legislation, not on the amendment.
I will recognize myself and yield to the gentleman.
Thank you, Mr. Chairman. I just, something was said that I thought was just greatly exaggerated the impact of this legislation. That somehow the number of potential acquiring companies would be dramatically reduced. I mean, this is a bill that would literally only impact 4 big tech companies. And so I just think it's important to clarify for those who may be confused about, the opportunities that would still exist for these smaller companies as proposed by my colleague from North Carolina. And I say this as someone who's not going to vote for this amendment, because I think that once we acknowledge that these companies are monopolies, we should be opposed to their growth. But I just think it's important to clarify that, and I yield back.
The gentleman yields.
Would the gentleman yield for a question?
I will.
The gentleman just said this would only affect 4 companies, and maybe they're hearing my point, but we've had this debate. If it only represents 4 companies, are we in fact clearly doing 4 companies, not covered platforms that might be more? We've never settled the question of Microsoft here, which would make it 5. Certainly, we haven't gotten into Twitter and lots of other companies that enjoy tremendous market power. It does seem like they're saying that, but on one hand, they're saying that they've done all these acquisitions, and that's a lot of acquisitions. Now I just heard, well, there aren't very many acquisitions, but if you were any of these companies that were acquired by those 4 or 5 companies, you certainly, I think, wanted them to be bidders, because in every case they were the high bidder. I think the gentleman, if you could at least tell me how many companies do you think these bills cover?
Mr. Chairman.
Who seeks recognition?
Would you yield?
I yield to Mr. Cicilline. Mr. Jeffries. Or to Mr. Jeffries, rather.
Yeah, I think that the legislation is clear, as with the other bills, that ultimately that's a determination that will be made by the FTC. I'd also add that I think entrepreneurs have at least 3 options consistent with what is available in America's market-based economy, that yes, there will be some entrepreneurs presumably who are developing a company with the objective to sell it, and they'll still be able to sell it in this environment if this legislation is offered. It's just that the burden in terms of demonstrating that that sale won't have an anti-competitive effect on consumers is shifted from the FTC to these multi-trillion-dollar companies that meet the definition of a covered platform. But beyond sale, you can still grow a company and then take it public into the stock market, or you can grow the company and maintain it as a successful privately held business. Multiple options that are available to allow innovation and entrepreneurship in America to flourish. I yield back.
The gentleman yields back. Oh, I yield back. The question occurs on the amendment. All in favor of the amendment will say aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. And the amendment is agreed to. Are there any further amendments to the amendment in the nature of a substitute? For what purpose does Mr. Roy seek recognition?
An amendment at the desk.
The clerk will report the amendment.
I reserve a point of order, Mr. Chairman.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3826, offered by Mr. Roy of Texas. Page 1, strike line 4, and all that follows through the amendment to the title on page 15.
Without objection, the amendment is considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Chairman. As we've been discussing, I do believe the goal of the underlying bill that we need to make it easier to challenge mergers of these very large companies as I've already established, I have some concern about how we define those, is a reasonable goal and important. You know, acquisitions, as we've discussed, like Facebook's of Instagram, et cetera, obviously deserve scrutiny. But my concern is that the underlying bill will have the effect of its starting place is outlawing, you know, all mergers by these covered platforms. I've already described my concerns about the definition of the platforms, and that's overall bad for the market, and that it doesn't necessarily consider consumer value, does not consider the monopoly power in the given market. It makes the burden clear and convincing evidence to allow any merger for these covered platforms to go through, in some ways almost insurmountable, which may be viewed as a feature, not a bug. You know, nearly 60% of all startups have as their express business strategy to be acquired. We've been talking about that. VC-backed startups disproportionately positively impact innovation. You know, M&A is an exit option, frees capital for innovative investments instead of locking capital into a long horizon. So that's obviously, you know, what drives a lot of the investments. 90% of U.S. startup exits happened through acquisition between 2008 and 2019. You know, this bill, as the best I can understand it, would have stopped at least 100 acquisitions over the last 5 years. And that sort of thing, you know, I've already mentioned when the gentlelady from North Carolina's amendment, it would disproportionately, in many ways, impact the district I represent in Austin, Texas, San Antonio, in many ways, to some degree, versus Silicon Valley. Startups often on the coast often grow large enough to go into public markets. My amendment that I'm offering here is the result of conversations that I've had with Senator Lee and Senator Lee's efforts in moving legislation in the Senate. I think it is a different approach that I think is in my view, better approach at trying to target and tackle the problem. And my amendment is designed to protect the startup ecosystem, protect innovation, and achieving the goal of making it easier to challenge mergers when the resulting firm is dominant in a given market. It creates a presumption against mergers where the combined firm would have the market power to meaningfully increase prices or reduce output innovation or quality. And two, the combined firm's market share is more than 1/3 of a given market. It allows companies to rebut the presumption when the weight of the evidence, a preponderance, shows no anti-competitive effects or that pre-competitive effects outweigh them. We shouldn't demand more proof than that, in my view. We should err on the side of letting the market sort it out. But I do believe that we should put in structures and standards in place to be able to deal with the obvious concerns we all share. I believe my amendment furthers the goal of the underlying bill without the harm that I think some of us, or at least speaking for myself, believes could result from the way that we're going about it in the current form. And again, I want to reiterate my belief that there's a good faith effort here to try to address this problem. And I've had many conversations with colleagues on my side of the aisle generally about the goal to try to address this problem of the anti-competitive behavior that we're seeing from certain companies. But without repeating myself, I have strong reservations about the way we've defined these, and I would like to focus more on the behavior than these arbitrary ways in terms of how we define this. So this is an attempt to do that. I think it's in keeping with the purpose and spirit of what we're trying to accomplish. With that, I will yield back.
Does the gentleman insist on his point of order?
I do, Mr. Chairman. The proposed amendment expands the bill beyond the confines of the underlying bill and amends an entirely different section and therefore is not germane.
Does the gentleman wish to?
Yeah, I mean, I'd like to address that.
You heard on the ruling?
Yeah, move to strike the last word. Is that what I do? Or whatever. Understanding the point being made, I still think it's worthy of debate in this committee when we're talking about something as fundamental as restructuring and changing the burden that these companies face. And here, trying to address it in a different way, in my view, in good faith, to say, hey, let's focus on the fact that these guys are reaching a certain dominant portion of the market, rather than saying, hey, we're defining a class of companies that will then change over time and say, we're just going to say, you can't acquire, unless you can come forward and prove X. I think the government should still have to be able to come in and say, hey, you guys, all the market, by the way, this amendment that I'm offering is it's broad, it's saying anybody, but it's changed to say that if you've got a third, right. But
That's the whole point, Mr. Roy. What's what makes it not germane, that it broadens it to the entire market. And it's an interesting debate, but for purposes of this hearing, it's not germane to the bill before us.
Chairman, who has time to us?
You have the time.
So, right, I understand that, look, I mean, I understand the technicalities of germaneness. I mean, I was a lawyer on the Senate Judiciary Committee. I get it. The point here is it's germane to the debate. It's definitively germane to the debate, because the whole point of the debate is about what we're going to do about how certain companies can acquire other companies. And the whole point here is to try to have a debate about antitrust and the size and scope of these companies, whom they can acquire. And all I'm trying to say is I think we ought to go about it a different way. So I think that's
And Mr. Roy, if you'll yield, I look forward to working with you on this issue.
The gentleman has.
I would yield to the gentleman if I can, if I'm allowed. Yeah.
Thank you.
No. The chairman is prepared, the chair is prepared to rule. Clause 7 of House Rules 16 prohibits amendments that are on a different subject matter than the proposal that is under consideration. The subject of the bill we are currently considering is anti-competitive acquisitions by covered platforms. The gentleman's amendment proposes to amend Section 7 of the Clayton Act, which the bill does not amend and applies to the entire economy, not just to covered platforms. This is a subject that is different from what we are considering in this bill. The amendment is in this bill. The amendment is therefore not germane and violates Clause 7 of Rule 16.
Appeal the ruling of the chair.
Move to table.
Move to table.
The motion to table is not debatable. All in favor, say aye.
Aye.
Opposed, nay.
No.
The motion, in the opinion of the chair, the ayes have it.
As for the ayes and nays.
The ayes and nays are requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee.
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries. Mr. Jeffries votes aye. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell.
Aye.
Mr. Swalwell votes aye. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal. Ms. Jayapal votes aye. Ms. Stimmings. Ms. Stimmings votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Ms. Scanlon votes aye. Ms. Garcia. Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones. Ms. Ross. Ms. Ross votes aye. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye.
Madam Chair, how am I recorded? Madam Clerk, Hank Johnson,
Mr. Johnson, you are not recorded.
vote aye.
Mr. Johnson of Georgia votes aye. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Gomert? Mr. Issa? Mr. Issa votes no. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stube?
No.
Mr. Stube votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach? Ms. Fishbach votes no. Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens votes no.
Mr. Deutsch?
Mr. Gomert votes no.
Mr. Deutsch?
Aye.
Mr. Deutsch votes aye.
Are there any other members who wish to vote who haven't voted? The clerk will report.
Mr. Chairman, there are 23 ayes and 19 noes.
The gentleman's appeal of the chair's ruling on the germaneness of the Roy Amendment is laid on the table. Are there any further amendments to the amendment in the nature of a substitute?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3826, offered by Mr. Tiffany of Wisconsin, beginning on page 4.
Without objection, the amendment, the reading of the amendment is waived, and the gentleman is recognized.
Thank you, Mr. Chairman. What this amendment does is a server in China will be required as a covered platform. Without this amendment, this bill could present a serious threat to Americans' privacy and our national security. And we've been seeing those threats here, especially over the past decade. I mean, I think about what happened in Houston last year, where we had to clear out the Chinese embassy. And I think about companies like Google and NBC and others. I mean, they've given up their info, huge companies that have felt so threatened by the Chinese Communist government that they just give up some of their information. We have to prevent Chinese companies, in particular those with ties to the Chinese military and intelligence apparatus, from acquiring companies that hold Americans' sensitive data. We should be very concerned with members of the CCP and its aggressive military and intelligence services having access to Americans' data. More about that in a second. The CCP has conducted cyber attacks against the American government and U.S. companies to steal sensitive personal information about Americans. The CCP has breached a large American health insurance company, a consumer credit reporting agency, the Office of Personnel Management, and the list goes on. The CCP has further used social media platforms and mobile applications to collect information on Americans. Allowing the CCP to acquire American companies and almost certainly Americans' data would be disastrous. I'm going to read something to you that I just received tonight, just a couple hours ago. I suspect many of you are familiar with Apple Daily, which has been shut down. Here's the message that they sent out. Thank you for being a subscriber and loyal reader. Tonight at 11:59 p.m. Hong Kong time, that's tonight, we will cease publication. Good luck and goodbye. I mean, think about that. I mean, they just wiped out the Apple Daily, one of the best publications that talked about the news coming out of Hong Kong, China, Southeast Asia. They are gone. That's the kind of threat that the Chinese Communist government holds all over all of the world, including the United States. So I urge all of you to vote for this amendment. If you want to make sure and protect Americans' data, America's security, we need to adopt this amendment, and I sure hope that you will do that. I got a couple of minutes here yet, Mr. Chairman. I want to comment on one thing that I heard a little bit earlier from the gentlewoman from Texas. She was talking about consolidation, and she specifically mentioned the banking industry. And she was also quoted during her remarks, which is absolutely correct, innovation is important. But she commented about the integration of the banking company, or the banking industry, where we're seeing fewer banks as a result of acquisitions. And I got to tell you, the point that she was making actually is a point in regards to the bills that we're hearing tonight that you probably shouldn't support them. Because do you know what precipitated this? It was Dodd-Frank. It was Dodd-Frank over a decade ago. All you have to do, and I've done it in our state of Wisconsin, is look at when the Dodd-Frank law was passed, we stopped having new community banks that were formed. I wish I had the data before me, but I'd be happy to get it for anybody that's interested in it. New entrants into the banking industry virtually stopped with Dodd-Frank. And I understand it was a well-intentioned piece of legislation, but let's look at the results that happened. Is the same thing going to happen here? If this stuff passes, it's very possible. I mean, that to me was really a warning sign by citing the banking industry. And even the oil industry is true of that, where we've seen real integration of the oil industry and not having as many new startups, and a lot of that is because of so much regulation. I believe in regulation, but it needs to be done in an appropriate sense. This is really giving me even more pause about what we are hearing tonight. But anyhow, to the amendment, in regards to servers in China, I believe they should be a covered platform, and I hope you'll support this amendment. I yield back.
Gentleman yields back. Who seeks recognition? The gentlelady from, for what purpose is the gentlelady from California?
To strike the last word.
Gentlelady's right
Mr.
now.
Chairman, point of order. I believe I've reserved a point of order.
I'm sorry.
Oh, yes.
Mr. Chairman, I'd like to press my point of order. I think the amendment clearly expands the scope of the bill. Currently, we have a very well-crafted definition. It has to meet 3 requirements: market capitalization, monthly users, and be a critical trading partner. This eliminates 2 of those, simply has the $600 million market cap, and then expands it to servers in China. So you've expanded it essentially outside the borders of the United States, and you've removed the other 2 requirements for all businesses over $600 million. So it's significantly expanding the reach of the covered platforms and actually doing it outside the United States. So I don't think it's too easy.
Does the gentleman wish to be heard on the point of order?
Yes, may I comment, Mr. Chairman? So as I'm looking at the bill in regards to implementation, covered platform designation, Federal Trade Commission or Department of Justice shall designate whether an entity is a covered platform. I mean, isn't this similar to what we did with the $50 million? Isn't that's similar to that amendment? So I think that there is a place within this bill to be able to insert this, and even more importantly, in regards to, I think our national security is always important, regardless of what we're doing. So I think we have the place to insert that here in this bill, especially in light of the amendment that we just heard.
Mr. Tiffany, will you yield?
Yes, I will yield.
I think the difference in the Ross Amendment, that narrowed the scope of the bill. This expands it, so it's exactly the opposite.
Would the gentleman yield?
Yes.
Briefly,
I'll yield to the gentleman.
I've never heard that expanding the scope within our jurisdiction, within a section, is a germane question. The fact is that defining covered, you're simply adding additional defined covered. There's nothing inconsistent with that under our jurisdiction. It can't possibly fall outside of our jurisdiction or the intent of the bill, which is to define a covered platform. And as the gentleman said, we're adding and subtracting covered platform all the time.
The chair is prepared to rule on the point of order. Under House precedents, an amendment to a definition is generally in order, and therefore the appeal of the rule, the amendment is in order.
Thank you, Mr. Chairman.
Mr. Chairman?
Yeah, I mean, I think we've stated the case here. Whether an entity is a covered platform, I mean, that's where this fits in, is it's under a covered platform. And it's just so important. It is so important to put this in with what we've seen from the Communist Chinese government, with what they're doing in our country, whether it's in our universities, whether it's like in Houston, Texas, with our embassy. We have to make sure that we protect Americans' information. We've been talking about that all tonight, is that we want to make sure we protect Americans' data. And this will accomplish that.
Would the gentleman yield?
I will yield to you, yes.
First, a concern. I don't want to reaffirm the market capitalization amount that I object to, number one. But number two, a question on the servers located in China to host the platforms. There are platforms where the data travels through servers in China, even though they're not hosted in China. And I am aware of some companies who've managed to do that successfully through encryption so that the Chinese government is unaware of the data flow or the contents of the data flow. What you're trying to accomplish, I agree with, but I'm wondering as to the scope and whether it would include data flows that are encrypted through networks that are really not hosted.
Yeah, Madam, if it's traveling through China, then I believe it should be regulated under what's being proposed in this bill.
Okay, thank you for answering the question.
And, Mr. Chairman, I yield back.
The gentleman yields back. Who seeks recognition? For what purpose does Mr. Shabbat seek?
Who struck the last word?
Gentleman's recognized.
Thank you. I'll be brief. I would comment, I think it's an excellent amendment. I appreciate the gentleman offering it. I would hope that this would get bipartisan support. We all know that the Chinese Communist Party is trying to obtain as much personal information on all of us as well as every citizen of this nation. This is a national security issue. I would hope, if you care about national security on either side, that you would support this amendment. It's a great amendment, and certainly have my support, and yield back.
The gentleman yields back. For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Mr. Chairman, again, I rise to urge my colleagues to vote against this amendment. The legislation before us has provided a definition for covered platforms that identifies three factors. That is the market capitalization. Does the online platform have at least 50 million US-based monthly active users? And is the platform a critical trading partner as defined in the statute? This takes away two of those. And this definition was developed as a result of the market dominance, the extraordinary market dominance of the largest technology platforms in the United States for a reason, because of the market power they had, and to shift the burden as to acquisitions by designated platforms that have that kind of dominance. So it's removed two of the tests to determine whether it's not a covered platform, and then says either $600 million or has servers in China. The purpose of the underlying bill is to promote competition in the United States, to create jobs, to foster innovation. That's why the definition was developed. That was included in the bill and amended by Ms. Ross's amendment. This does not achieve that objective by taking away two factors and expanding it to all platforms with a value over $600 million or that have servers in China. It doesn't achieve the objective of the underlying bill. This was a definition that is aligned in all of the legislation that we're considering tonight. And again, I urge the committee to reject this amendment and stick with the covered platform definition, as that is the one that is really going to promote American innovation, job creation, competition, all the things that we know are important for a strong economy. And with that, I yield back.
The gentleman yields back. For what purpose does Mr. Gomer seek recognition?
Strike the last word.
Gentleman is recognized.
And I would like to yield at this early time of the hearing to my good friend from Wisconsin, Mr. Tiffany.
I hope the gentleman is being sarcastic when he says early time.
It's early
Perhaps
in the
I
morning.
wasn't. Oh, yeah, it is early. 1 a.m.
It's early Thursday.
Mr. Tiffany?
Thank you, Mr. Gomer, and I know you're not sarcastic in situations like this. So I think the point was made by the gentleman from Rhode Island in regards to market dominance. I mean, think about it. The Chinese Communist Party versus Google. Google's knuckled under. Google has knuckled under in the past. Who do you think is more powerful? I mean, we've seen it. It is the Chinese Communist Party. And they've done it in a whole variety of ways, including to the biggest of the big tech companies, to Google. And what can be more important, though, than American security, than our national security? Nothing's more important than that when we're discussing this. I think this is clearly germane, and I think this is one of the, there's been many good amendments here tonight, but I think this is so important to adopt this amendment. If you believe that Americans' security of their data is important, if you think America's national security is important, you got to vote for this amendment. Thank you for the time, Mr. Gomer.
The point is very well made. The actual language or that uses servers located in China to host the platform, that's just common sense, and I hope that we can have a bipartisan vote to affirm that. That ought to be in there. It ought to be there to protect the United States and our, as my friend from California across the aisle had pointed out earlier, we know that high-tech companies have already provided private information to China. So I applaud the gentleman for bringing this this amendment, and I would encourage everyone to support it. Thank you. I yield back.
The gentleman yields back. Does Mr. Ice, for what purpose does Mr. Ice seek recognition?
Mr. Chairman, I want to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I appreciate the gentleman from Rhode Island wanting to maintain the 4 companies that he has tried and convicted and now wants to have this bill go after. And I say it at this early hour because it is becoming more and more obvious that any amendment that would possibly include even one more company would break up this perfect Henry VIII sort of a system where we found 4 companies and only 4 companies, and we're going to hang those 4 companies with these rules. And I find it more and more transparent that the idea that you'd have, let's just say Alibaba or somebody like that, get covered by this just is unacceptable. And I find it amazing that we can't find any possibility that some other company might have to meet this test. Just 4 companies. 4 companies, and 4 companies that each came to market dominance in a different way. And I'm old enough to remember that Apple had to get a bailout from Microsoft because it was on the skids and just about out of business, having stammered and stuttered a little bit. They had been a good leader early on, and they fell apart. Yes, they are back on the top today, but they're still actually quite a narrow company. And I find it amazing that we're going after Apple, which does have about half the world's smartphones, but of course it also did invent the smartphone, innovate it. The late Steve Jobs bet the company first on the Mac, or first on the Apple, but then on the Mac, having failed with the Lisa and his other earlier ones. He bet the company. Then when his successor screwed it up, he came back and he fixed it, but he reinvented whole new categories. He didn't buy somebody's company and bury some technology nearly as much as he hit home runs by creating some amazing products. And for the most part, today, that $2 trillion company is, for the most part, those exact products that the late Steve Jobs left the company. I don't know whether Tim Cook's going to build successfully or not. What I do know is that as we're vilifying Facebook and Amazon and Google, we've also thrown a company in that doesn't even fit the rest of the model. And I guess we're upset because of something, because if we held up the phones, there's probably 4 people in this room that have a phone other than an Apple. So we're going to be upset that we've got this product because somehow the product that has reinvented how we do business must have ruined our lives and ruined everything else. Well, I, for one, think that including and expanding is the only way to save any legitimacy to what we're doing. And if we don't, and I caution if you don't, I suspect that the court will strike down this legislation if it ever becomes law, because it is transparently this evening become nothing but an attack on 4 companies that have been tried and convicted by a subcommittee. And I know that there is a lot of good merit and a lot of things that were done wrong, and we've all seen things that we'd like to see changed. But I don't believe for a moment that when you resist any expansion to any other company, that it's anything but trying and convicting 4 companies. I'm not prepared to do that tonight, and I don't think I'll be prepared to do it in the weeks to come. And I thank the chairman, and I yield back.
The gentleman yields back. Who seeks recognition? Mr. Roy, for what purpose does Mr. Roy seek recognition?
Strike the last word.
Gentleman is recognized.
I just want to thank the gentleman from Wisconsin for offering this amendment. I think it is a good amendment. I think if the purpose of these bills is to target and reduce the power of certain bad actors, why not the Chi-Coms? I mean, I just don't get it. We all get that the harm that they're perpetrating and the danger that they pose to the United States, not just from a national security standpoint, but generally speaking with respect to impact on our markets and what they do in terms of their own anti-competitive behavior, in terms of what they do with respect to stealing intellectual property, with respect to espionage. It sure seems like this is a well thought out and good amendment, and I support it. I yield back.
The gentleman yields back. The question occurs on the amendment. All in favor say aye. Aye. Opposed, nay. Nay. In the opinion of the chair, the nays have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson-Lee? No. Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Cohen?
Aye. Or no, better yet, no. No.
Mr. Cohen votes no.
No is better.
Sign off.
Mr. Johnson of Georgia?
Johnson votes no.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
Niet. No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demmings? Ms. Demmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? No. Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa? Mr. Isa votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye.
Biggs votes aye.
Mr. McClintock?
Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Owens? Mr. Owens votes yes.
Are there any other members who wish to be recorded who have not been recorded? The clerk will report.
Mr. Chairman, there are 19 ayes and 24 noes.
The amendment is not agreed to. Are there any other amendments in the, to the amendment in the nature of a substitute?
Mr. Chairman, I have an
For what
amendment.
purpose is Mr. Issa seeking?
I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3826, offered by Mr. Issa of California, page 3, line 8, insert, intellectual property. Nothing in this act shall be constructed to limit a covered platform from acquiring or licensing patents, trademarks, or other intellectual property.
The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. As you can imagine, companies are constantly being threatened with violation or infringement of intellectual property, particularly patents, but patents, trademarks, and copyrights and the like. Companies often have no choice but to take licenses. Those licenses can be very expensive. They are not mergers in the sense of a acquisition of a business, but they may represent a substantial amount of money. Clearly, like the $50 million carve-out, this is a carve-out of a type of purchase. Having been in the world of technology, I have both licensed to others and taken licenses. They are not something that you necessarily do. They're not anti-competitive, and yet they could not meet the test for these covered platforms. So for these covered platforms, it's clear that this sort of a carve-out would at least make it clear that these kinds of acquisitions do not have to stand a test that might be impossible to test. Giving, let's just say, Microsoft a license versus a company that they couldn't meet the test of buying could well be the only way for Microsoft to continue doing existing business or to follow a normal train of development. These companies often, I'll give you the example, if you wanted to produce, when we all remember the DVD, there was a packet of literally dozens and dozens of various optical and other technologies owned by multiple companies. The only way you could produce a DVD was to buy or license the entire packet. It wasn't cheap. It happened to be sold on a per-piece basis, but some are sold in lump and some are sold per piece. So can't predict what those are cost. It might be a few $1 million, but it might be a few $1 billion. As we know, for example, I believe it was Intel just lost a patent suit against a non-practicing patent holder, and I believe the award was more than $1.2 billion. If one of these covered companies finds itself in that situation, they could find themselves between a rock and a hard spot. So that's why this very narrow carve-out, similar to the $50 million, was designed to recognize that we are talking about acquisitions of full companies and not the often necessary acquisition of intellectual property. And with that, I'd yield to my friend, Ms. Lofgren.
Thank you for yielding. I'll be honest, I hadn't actually thought of this before.
And neither had I.
Her amendment, and I think it's a good amendment, but it also shows the problem with the underlying bill, which is you don't have to engage or even be alleging to engage in anti-competitive practice. And that's the whole point of what we're trying to do here. I think, unfortunately, because of the underlying bill, your amendment is likely necessary and I would support it. I mean, if you can't do this, you're going to end up in other problems. But I think this is just another example of why going back to standards of competitiveness we'd be on much firmer ground. And I do think that the standard in law today is too low and needs to be adjusted and the burden needs to shift. I don't disagree with that, but it should be about competition. And I thank the gentleman for yielding.
I thank the gentlelady, and with that, you want your own time or you want to use mine?
I'd like my own.
Then I'd yield back.
Thank you.
The gentleman yields back. Does the gentleman from Rhode Island insist on his point of order?
No.
Gentlemen, the point of order is withdrawn.
Thank you. Mr. Chairman, I seek recognition in opposition to the amendment.
For what purpose does the gentleman from Rhode Island seek?
Move to strike the last word.
Gentleman is recognized.
I'll just say very briefly that I believe this is an inappropriate carve-out. Just as an example, Google acquired Motorola for billions of dollars solely for its patents. And the test should be if it expands their market power, there's no reason to treat this kind of acquisition differently from any other kind of acquisition. And so I urge you to vote no on this amendment. It's an inappropriate carve-out, and I yield back.
Gentleman yields back. Does anyone else seek recognition on this amendment? Not, the question occurs on the amendment. All those in favor say aye. Aye. Opposed, no. No. In the opinion of the chairs, the chair, the noes have it.
Mr. Chairman, could we possibly verify that with the recorded vote?
You certainly can. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
Yes.
Ms. Lofgren votes yes. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
Aye.
Mr. Stanton, you will have to turn your camera on to be recorded.
Aye.
Mr. Stanton votes aye. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa? Mr. Isa votes aye. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Aye. Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes yes. Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Owens? Mr. Owens votes no.
How am I recorded?
Ms. Jackson Lee, you are not recorded.
No.
Ms. Jackson Lee votes no.
Has everyone who wished to vote, who wished to be recorded, been recorded? The clerk will report.
Mr. Chairman, there are 17 ayes and 25 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute?
As a matter of fact, Mr. Chairman, I have one at the desk.
The clerk will report the amendment.
Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3826, offered by Mr. Isa of California. Page 3, line 8, insert. Bankruptcy proceedings. Nothing in this act shall be
The amendment,
construed.
without objection, the amendment is considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman, and I'll finish the reading for clarity. Bankruptcy proceedings, nothing in the act shall be construed to prevent a covered platform for acquiring assets or businesses from a bankruptcy proceeding. And it means just what it says, Mr. Chairman. Bankruptcy is a shifting of a great many priorities. And in short, if a company goes into bankruptcy, a bankruptcy judge is overseeing and attempting to get the highest and best value for the creditors. In that situation, a great many other items, including whether their data is being gathered and the like, the balance really comes down to you want to make sure you have the highest bidder. Bankruptcy is not something people enter to lightly, but it happens, and it happens very often. So to not have these four large companies, along with Berkshire Hathaway and plenty of other companies, able to bid for a company and bid quickly what you have in this situation under the underlying bill is you have a great deal of delay and uncertainty that would make it impossible for these 4 companies to bid in bankruptcy in an effective way for all or part of a company, any of its portfolio and the like. You have to be able to go to the bankruptcy court and go with their timelines, go with their requirements, and you have to make a commitment, which you cannot say, I'm making the commitment, but mine is subject to a 120-day delay. It's subject to interference with others and perhaps an adjudication that you don't know how it's going to go. So in the situation in which the federal court is already involved and they're making a decision on behalf of an entity, that entity could be large or small, but these 4 companies clearly should be able to represent the highest and the best value for the creditors. And that's the reason that I think it is a narrow carve-out, and it's quite frankly simply one that I think was unforeseen by the authors, that in addition to others, you might have this occur. But in the real business world, this occurs all the time. And in technology, it occurs a lot more often than people might think. And you have to be able to bid and bid without asking the FTC in advance of a deal that you don't have. So that's the reason that I thought that this narrow one would probably slip past the objections of some, and I think it will, because I believe that it won't happen that often, but when it does happen, we want to make sure that the creditors and the employees and so on get the best synergy and the highest value, and that would include all bidders at the table. And with that, I thank this chairman, and I will yield back.
The gentleman yields back. Does the gentleman from Rhode Island insist on his point of order?
I withdraw my point of order, but I seek recognition in opposition.
Point of order is withdrawn. The gentleman is recognized.
I would just say once again, I don't think this is an appropriate carve-out. The value, the asset value of a company in bankruptcy can still be very substantial. It only has to be that their liabilities exceed the value of their assets. Radio Shack is one that comes to mind, had very, very valuable patents. There's no reason to treat those any differently for purposes of this piece of legislation. I urge my colleagues to vote against this amendment.
Gentleman yield back?
I yield back, Mr. Chairman.
Gentleman yields back. For what purpose does Mr. Gates seek recognition?
Strike the last word.
Gentleman is recognized.
Yeah, I would point out that a company in bankruptcy can have substantial assets, and you might even see a perversion of the bankruptcy laws where people would try to access bankruptcy just for the point of facilitating an acquisition that might not otherwise be allowed. But the real problem I have with this amendment is one of priorities, because the amendment seems to prioritize creditors getting their money over the health of the marketplace. And I think the author of the amendment was pretty clear that that is the equity that he values most, but the objective of the committee ought to be to keep the marketplace healthy, even if a few creditors have to take a little less from a company in bankruptcy. I yield back.
The gentleman yields back. Wells seeks recognition.
Mr. Chair.
For what purpose does the gentleman seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you, Mr. Chair. So it would be helpful if someone who helped write this bill could define the term in line 4, page 2, the whole or any part of the assets. I do not see a description or a definition of the term assets. So for example, would the assets mean something that you need every day in the operation of your business? Or are you suggesting it's something larger than that? If anybody knows.
Consistent with the Clayton Act.
And you'll have to forgive me, but I don't enjoy the knowledge that you apparently do. Perhaps you can share with me.
Anything of value.
Anything, so let me see if I have this right. This means that once this bill passes, these 4 companies cannot buy anything. Is that what you're saying?
If the gentleman will yield.
What can they buy?
If the gentleman will yield. Is the gentleman?
Yes, I'll yield. Go
Okay,
ahead, please.
Thank you. So if they are a covered platform, the presumption shifts for their acquisition, and they have to demonstrate their acquisition will not enlarge their market dominance and impair competition. And so it doesn't prohibit mergers. It simply says the burden shifts to the acquiring platform to demonstrate that they will not enlarge their market dominance as a result of that acquisition, and thereby diminish competition, innovation, and all things that come from a competitive market. Doesn't bar any transactions. It simply shifts the burden to the covered platform to demonstrate that the acquisition will not do those things. Nothing more.
You yield back.
Time I yield
Would the
back,
gentleman,
yes.
Would the gentleman yield?
I'll yield, sure.
Mr. Vince, you would yield to me? Would you yield?
I yield, sure.
So I just want to understand the import of your question and your colloquy with Mr. Cicilline. So if, say, Google wants to go out and buy a ream of copier paper, then they would need to prove to the FTC these 4 prongs here. They'd have to, is that what your understanding is?
I think that's what we just heard, if that ream of paper would assist Google in conducting its business and competing, which Google probably does as a business.
Wow. Thank you, sir.
would the gentleman further yield?
Yes.
I think another example might be if we put the post office up that's been losing $10 billion out of $60 billion worth of revenue every year for a decade now, if it went up for sale, Amazon would not be able to buy it, even though they could run it better, even though it would be good for the consumer, because of course it would increase their market share. So yes, the all or part would include about anything from paper, if it was over $50 million, to even the post office, even if you would in fact be benefiting the consumer, but you would clearly be reducing competition. And it's one of the reasons that I included bankruptcy, because our post office is currently beyond bankruptcy. The only reason it doesn't enjoy the term bankruptcy is because you and the other taxpayers are bailing out their billions of losses every year. So you're exactly right to point out one of the flaws in the bill, which is, yes, they are prohibited from buying all or part of anything unless this passes, and then it'll be up to $50 million.
Mr. Ice, if you'll yield, I'll explain to you why. Oh, I'm sorry.
So just so I'm thinking that perhaps if Google had lost maybe $10 million in the previous year, it could, I guess it doesn't quite know when it has to establish this baseline, but maybe it could add $10 million back, but we're not quite sure what baseline we're working from. So is it more competitive now than it was then? You get my drift. So, but I'd love to be enlightened. I yield back.
The gentleman yields back, and I will recognize myself to strike the last word, and I'll yield to Mr. Cicilline.
Thank you, Mr. Chairman. With respect to the suggestion of having to buy paper, that would not be required to be reviewed according to the Section 7AC of the Clayton Act, which is specifically exempted in the bill. In addition to that, the acquired assets do not compete with the covered platform or covered platform operator for the sale or provision of any product, constitute nascent or potential competition. So it has to meet one of those things, and it does not meet any of those. So you are not precluded from making acquisitions that relate to paper. And with that, I yield back, Mr. Chairman.
Would the chairman further yield?
Yes.
My understanding is Amazon does sell a lot of paper. And I also understand that Amazon delivers in competition to the post office. So at least in the examples that we were using, yes, it would fall under this prohibition. And even if the post office or UPS or somebody went into bankruptcy, they wouldn't be able to compete for bidding, even if they were the best future operator, because consumer benefit is not in the bill, just as question of sort of market share. If the consumer would benefit, that isn't the test here, where under current bankruptcy law, under current antitrust law, it would be a consideration. The consumer benefit would matter. It's not mattering the way you've written this bill for these covered platforms. Thank the gentleman for yielding.
I'll yield back. Does anyone else seek recognition on this amendment? In that case, the question occurs on the amendment. All those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it. The ayes and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes no. Mr. Isa? Mr. Isa votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fischbach? Ms. Fischbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes yes.
Has everyone who wishes to vote, has everyone who wishes to vote voted? The clerk will report.
Mr. Chairman, there are 16 ayes and 26 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? In that case, the question occurs. Yeah. Yeah. The question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote of final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 3826 is amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. No. The ayes have it, and the bill is ordered reported favorably to the House. On this, the ayes and nays are requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. No. Ms. Lofgren votes no. Ms. Jackson-Lee. Ms. Jackson-Lee votes no. Mr. Cohen. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
Aye.
Mr. Deutsch votes aye. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries. Mr. Jeffries votes aye. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell.
No.
Mr. Swalwell votes no. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal. Ms. Jayapal votes aye. Ms. Stimmings. Ms. Stimmings votes aye. Mr. Correa. Mr. Correa votes no. Ms. Scanlon. Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones.
Aye.
Mr. Jones votes aye. Ms. Ross. Ms. Ross votes aye. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye.
How am I recorded?
Ms. Jackson-Lee, you're recorded as no.
Aye.
Ms. Jackson-Lee votes aye. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat. Mr. Shabbat votes no. Mr. Gomert. Mr. Gomert votes no. Mr. Issa. Mr. Issa votes no. Mr. Buck. Mr. Buck votes aye. Mr. Gates. Mr. Gates votes aye. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes no. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock.
No.
Mr. McClintock votes no. Mr. Stubbe.
No.
Mr. Stubbe votes no. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy. Mr. Roy votes no. Mr. Bishop. Mr. Bishop votes yes. Ms. Fischbach. Ms. Fischbach votes no. Ms. Sparts. Ms. Sparts votes no. Mr. Fitzgerald. Mr. Fitzgerald votes no. Mr. Bentz. Mr. Bentz votes no. Mr. Owens. Mr. Owens votes present.
Has everyone who wishes to vote voted?
Mr. Chairman, there are
No, no,
24
no.
ayes, 17, oh,
Clerk will report.
Mr. Chairman, there are 24 ayes, 17 noes, and 1 present.
The ayes have it, and the bill is amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 3816, the American Choice and Innovation Online Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3816, to provide that certain discriminatory conduct by
Without
covered-
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 3816, the American Innovation and Choice Online Act, restores competition online and ensures that digital markets are fair and open. It does so by preventing dominant online platforms from using their market power to pick winners and losers, favor their own products, or otherwise distort the marketplace through abusive conduct online. The open internet has delivered enormous benefits to Americans in our economy. The internet and the services available online have increased economic opportunity and innovation and have greatly expanded access to information, communications, and education. Online platforms have been an important part of this success story. Businesses of all types rely on digital platforms to serve customers all over the world. Consumers rely on these platforms to communicate with one another and to enhance their lives. However, a small set of online platforms have become gatekeepers for much of the digital marketplace. In many cases, businesses and consumers no longer have meaningful alternatives online. As the committee's investigation has shown, these dominant platforms can have the incentive and ability to abuse their market power to pick winners and losers among the firms that rely on their platforms to reach users and customers. Additionally, these dominant platforms often compete directly against the very businesses that rely on their platform. This allows these gatekeepers to exploit their control over the platform to favor their own products or to exclude or disadvantage rivals. Such conduct harms competition. It eliminates incentives and opportunities for small businesses and entrepreneurs to compete in the digital economy, undermining innovation and depriving consumers of meaningful choice online. This legislation would address this sort of anti-competitive behavior by prohibiting certain forms of discriminatory conduct which causes harm to the competitive process. It also includes important safeguards. It ensures that online platforms may continue to police conduct, stop malicious and illegitimate activity, protect user privacy and security, and pull down illegal content. The American Innovation and Choice Online Act is bipartisan legislation tailored to improve opportunity and innovation online. It serves to prevent gatekeepers from abusing their power in ways that harm competition and consumers. And it does so without disrupting the benefits of the open internet and that consumers enjoy today. I thank Chairman Cicilline for his leadership on this bill, together with Congressman Gooden, and I urge all members to support it. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This bill would give the Biden administration extensive new power to define and prohibit a wide variety of practices as, quote, discriminatory. This bill does nothing, as the previous four did nothing, to address the real problem, censorship, the limits on speech. In fact, it will mean big tech will censor more. Think about it. The Biden FTC will effectively have the power to approve or disapprove the business practices of companies. Do you think the Biden appointees are going to look more or less favorably at business practices that advance, quote, woke causes? They won't even have to say it. The companies will know that if they don't heel to the Democrats, they won't be able to make as much money. That's how business in America, that's not how business in America is supposed to work. To accomplish all this, the bill creates a new Bureau of Digital Markets, a fourth bureau at the FTC charged with enforcement, solely with enforcement of this legislation. So a couple bills ago, a few hours ago, in the so-called access bill, we had the secret committees. Now we have a new bureau. And even if you agree with the premise of this bill, it's totally unnecessary expansion of the administrative state. The Trump administration already created a big tech and focused enforcement division appropriately placed in FTC's Bureau of Competition. This bureau was responsible for investigating all anti-competitive conduct in markets in which digital technology is an important dimension. This bill takes power away from judges, transfers it to regulators. If you want to challenge these rules, the bill demands clear and convincing evidence to establish unclear defenses, so firms can bring evidence showing conduct did not result in harm to the competitive process by limiting, quote, legitimate business activity. But none of these standards are defined. So again, this legislation and related rulemaking would interlock the government and big tech to the detriment of anyone who dares challenge Democrat orthodoxy. With that, Mr. Chairman, I yield back.
The gentleman yields back. I now recognize the chair of the Subcommittee on Antitrust, Commercial, and Administrative Law, the gentleman from Rhode Island, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman. I'm proud to be the sponsor of H.R. 3816, the American Innovation and Choice Online Act. This legislation will stop the largest online platforms from using their gatekeeper power. It will ensure that there is free and fair competition online. Dominant platforms possess enormous gatekeeper power over the digital marketplace. Too often, they exploit their power to harm rivals and boost their own products and services. Ultimately, this conduct destroys competition and harms consumers. Firms that abuse their gatekeeper power to gain an advantage in the marketplace have less incentive to invest and innovate. Firms that have destroyed their competitors and hold their customers hostage have little reason to improve the quality of their products and lower their prices. H.R. 3816 includes prohibitions to stop dominant platforms from abusing their gatekeeper power to advantage their own products and services and discriminate against rivals. This bill also restricts other specific types of anti-competitive and harmful conduct. For example, dominant platforms will be prohibited from requiring users of the platform to buy other services to access the platform or for preferential treatment. This means that a dominant platform will be restricted from requiring the use of its advertising, logistics, or payment processing service in exchange for use of the platform. As a result, this bill will lead to a more dynamic and competitive digital economy, and I urge my colleagues to support this amendment to restore competition and to combat monopoly power online. And with that, Mr. Chairman, I yield back.
The gentleman yields back. I now recognize the ranking member of the Antitrust Subcommittee, the gentleman from Colorado, Mr. Buck, for his opening statement.
Thank you, Mr. Chair. At the beginning of the big tech investigation, I was skeptical about what we would find. I was fairly sure these companies were monopolies in the academic sense, but I didn't see what harm they were causing to small businesses or consumers. If a small enterprise was put out of business by big tech, I assumed that was just the unfortunate byproduct of our robust free enterprise system. Then we had a field hearing in Colorado. We heard firsthand from companies like PopSockets, Sonos, and Tile about the abuses they have suffered at the hands of big tech. This bill allows consumers, not big tech monopolists, to decide who wins in the marketplace. Online consumers will no longer face the Henry Ford conundrum presented by these companies. For those who may not remember, Henry Ford famously told Americans they could have any colored car so long as it's black. Today, we have Tim Cook telling consumers you can have any app you like so long as it's Apple. This bill would break the big tech stranglehold by freeing up competition. This bill is also a pro-small business bill. It levels the playing field, but importantly, it respects our free enterprise system because it does not pick winners and losers. This bill means that entrepreneurs will no longer see their business ideas stolen and products throttled by Amazon once they have become successful. Leveling the playing field for small business is a worthy policy goal because it is the backbone of our economy. Small businesses employ approximately 60 million Americans, or about 47% of Americans in the workforce. According to their 10K reports filed with the SEC, Google, Amazon, Apple, and Facebook employ about 1.639 million people worldwide. This bill does not create a heavy-handed new regulatory scheme. It does not establish a new agency ripe for capture by industry. It is narrowly scoped and addresses the problem of big tech discrimination through classic American antitrust solutions, prioritizing free markets and access to the internet highways of commerce. It also aligns with conservative views of how government should interact with the private sector, not dictating outcomes, but ensuring the market function in a free and neutral manner. Republicans must stand with American consumers and small businesses against big tech monopolies and their lobbyists. And with that, Mr. Chair, I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3816, offered by Mr. Nadler of New York. Strike all after the
Without
enacted clause.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. In addition to certain technical revisions to enhance clarity and to make conforming changes, the amendment in the nature of a substitute makes several substantive changes which serve to strengthen the bill. The amendment makes technical changes to Section 2E of the bill to clarify when and how the agencies may remove a covered platform designation. The amendment also makes technical changes to Section 2F of the bill to clarify that the Department of Justice, the Federal Trade Commission, and the Attorney General of any state may seek and the court may grant the specified remedies. In addition, the amendment adds to Section 2F that a court may order any corporate officer to forfeit the specified amount of compensation as appropriate to deter violations. In Section 2G, the amendment corrects a drafting error for the definition of the term online platform. In Section 2H, the amendment clarifies that except as otherwise provided, the Department of Justice, the Commission, and the Attorney General of a state has the same enforcement powers, duties, and other authorities under this Act as in certain other relevant antitrust and procedural statutes. The amendment makes final technical edits to Section 3 of this bill to clarify the scope of judicial review. Finally, the amendment makes an important substantive change to Section 7 of the bill to establish that actions taken by a covered platform operator that are reasonably tailored to protect certain intellectual property rights shall not be considered unlawful under Section 2. I urge members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? Are there any amendments to the amendment in the nature of a substitute?
I have an
For
amendment.
what purpose does Mr. Jones seek recognition?
So I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
I want to thank you, Mr. Chairman, as well as Chairman Cicilline for introducing the American Choice and Innovation Online Act. I also want to thank Ranking Member Buck and Representative Gill for helping with this legislation. I am proud to co-sponsor the bill to secure equal treatment online for users and small businesses. There is no question that today big tech writes the rules of the internet. The question is, should big tech be allowed to rig those rules? This bill is the American people deserve and demand. No. Enough of the biggest corporations telling us how to shop, search, and speak. There's no good reason that the corporation that
I sent him the text too. I'll keep
Amazon
the
should exploit small businesses products and destroy their livelihoods. There's no good reason that the internet's largest search engine, Google, should be scraping data from smaller competitors like Yelp and TripAdvisor, then ranking their results lower than its own. There's no good reason that Facebook should be able to devastate local independent journalism by conditioning news organizations access to its social network, using its ad market dominance. So it's time to restore and protect the fair, open, and inclusive online economy we deserve. And that's just what this bill would do. None of the big tech companies could engage in these practices, by the way, unless they show that they would not be anti-competitive or that they are necessary to protect privacy or comply with the law. There's a dark irony to how big tech has abused its dominance over small businesses. These massive corporations owe their early success to the free and open internet that they now deny to everyone else. If the big tech companies had had to overcome the same obstacles they now pose to others, they might never have taken off in the first place. Imagine if AOL had had the power to prevent its internet subscribers from switching to Gmail. Imagine if Yahoo had had the power to make it impossible to find Google. Or take an actual case. If antitrust action had not compelled Microsoft to give rival web browsers a fair shot to compete with Internet Explorer, Chrome might never have stood a chance. Today's biggest tech companies, the innovators of the past, are entrenching their power by making sure the innovators of the future don't have the same opportunities that they did. After climbing to the heights of power, these massive corporations are pulling up the ladder behind them so that no one else can rise. So fundamentally, this is a bill that would restore the fair and open online economy that the big tech companies once relied on themselves, ensuring that today's small businesses have the same opportunities that today's giants once enjoyed. And finally, I want to emphasize how important it is that this legislation includes a private right of action. The bill empowers anyone injured by a violation to have their day in court and to win treble damages. I'm proud to have championed this provision, and as excited as I am that the brilliant Lena Khan is now chairing the FTC, we may not always have such staunch anti-monopolists in power. And so a private right of action ensures that no matter who is in charge in Washington, the people have the power to right the wrongs of big tech. So I urge all of my colleagues in both parties to support this legislation. And with that, Mr. Chairman, I would yield back the balance of my time.
The gentleman yields back. Who seeks recognition? For what purpose does Ms. Lofgren seek recognition?
Just strike the last word.
Gentlelady's recognized.
Once again, we have identified an actual serious problem, which is large platforms that have a large share of the market, in some cases abusing that market share to the disadvantage of competitors. There's a long history in antitrust of industries discriminating and the government taking action about that discrimination. For example, common carriers such as railroads and freight companies and telecommunication providers and the like. So that issue is important, but before we get into it, I have to say, even though that's an important discussion, this bill goes so far, far beyond what would be necessary to address the specific real-world allegations of self-preferencing and other abuses by the platform, that it's simply extreme. In presumptively deeming broad and abstract categories of platform conduct as, quote, unlawful discrimination in Section 2, it would have a result that I think will be unwelcome in the country. I'll just give you one example. The bill broadly deems it unlawful for a platform to interfere with or restrict a business user's pricing of its products or services. What does this mean in practice? Would it include all limitations by Google or Apple and how apps are priced in their app store? What about Amazon regulating in any way how third-party sellers price their goods? And would this broad category of presumptively unlawful conduct prohibit Amazon or another platform from establishing price limits for certain products to prevent misleading price gouging? The other question about the overreach here is legitimate questions about how the bill might deem as unlawful, because it's preferencing one's own product, everything from Amazon Prime to pre-installed Apple apps. For example, Amazon Prime does preference Amazon products. And I'll tell you, I like Amazon Prime. I think if that were prevented from being available to American consumers, there would be great distress. Now, I recognize there is a defense, but that's only provable after months of litigation with a heavy burden of proof and requiring platforms to disprove any harm to the competitive process. And because there is a private right of action included in the bill, at a minimum, this would create a huge risk of unnecessary litigation for platforms throughout every part of their business. And given the way the bill is structured, I think it's highly likely this will include and promote bad faith, troll-style litigation trying to exact quick settlements. I think this reflects a basic flaw in how this bill is designed. By not requiring any sort of anti-competitive harm, anti-competitive intent, or any particular facts of concern in order to deem conduct as unlawful under Section 2. I think this creates a risk of drastic overreach far beyond what is necessary to address the specific harms and competitive risks. And just mentioning some of the alternatives, the platform product services and useful integrations would be presumptively unlawful. As I've mentioned, Amazon Prime could be eliminated because it advantages non-prime products. Google presumably would not be able to display Google Maps and with information boxes on that map. Apple would be blocked from pre-installing its Find My Phone in Apple's iOS because pre-installation advantages its product. Those are all in section 2A, 1 and 2 and 2B. I think there are other concerns about the bill relative to disinformation sites. If you discriminate among similarly situated business users, aren't you telling Apple that they can't kick InfoWars out of their app store unless they also do something about 4chan, Parler, and Gab? And if not, they're going to result in litigation. I think, as I say, there is a serious problem in this space, and it deserves a serious answer. But this bill is so flawed and is such an overreach that it will not actually solve the problems that we face. I say this with some regret because I know Mr. Cicilline has worked diligently for many months, really even years, and yet this bill does not provide the remedy to the problems that have been identified. So, Mr. Chairman, I see that my time has expired and I yield back.
The gentlelady yields back. For what purpose does Mr. Luce seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Chairman Nadler. And once again, I do want to thank Subcommittee Chairman David Cicilline for taking on this very challenging and tough issue. And you've identified a lot of practices that we do need to change. I am going to give you some of my concerns I hope you can work on prior to your bill reaching the House floor. My first concern is that your bill would arbitrarily give Walmart.com a massive advantage. If the committee believes that these practices are really bad and that they should be banned because they're anti-competitive, then why are we applying the bill to only a very small handful of companies? So for example, your bill would bar Amazon from giving preference to Amazon branded products. Yet Walmart.com would be able to give preference to Walmart branded products. Walmart has more retail sales than Amazon, and Walmart has a market cap of over $380 billion. Why would we exempt Walmart from your bill? In fact, your bill would give an unfair advantage to any online retailer not named Amazon. A few days ago, I entered a search query, Bose noise canceling headphones version 700. The search turned up over a dozen online platforms that sold that headphone. I'm gonna give you some of those prices. BestBuy.com was selling those headphones for $299. Amazon was selling for $329. QVC.com for $329. eBay for $374, and Nordstrom.com for $379. So for that headphone product on that particular day, BestBuy.com had a better deal than Amazon in a very robust marketplace with a lot of consumer choice. Yet of all these online platforms, each of which is also tracking your buying habits, we're applying your bill to only one online retail platform. We don't do this in other contexts in antitrust law. For example, current antitrust law bans price fixing. But we don't say, hey, medium-sized companies and large companies can engage in price fixing, but one really large company can't do that. We deem price fixing anti-competitive, so we ban it across the board. So my view is if this committee believes a practice is bad when Amazon does it, then it should be bad when Walmart.com does it or any other retailer. So I strongly urge that before your bill hits the House floor, you've got to change the definition of the covered entity. My second concern is that this package of bills, as written, will likely weaken cybersecurity. Apple has chosen an iPhone business model with a closed system. One advantage of that model is that Apple iPhones have better privacy and cybersecurity. There's far less malware on Apple iPhones because of Apple's iOS operating system and because Apple screens the type of apps that allows on the App Store. Your proposed bill, which in the way it also interacts with the interoperability bill, would appear to dismantle Apple's closed system approach that has resulted in better privacy and cybersecurity than other business models. One of the provisions of legislation could also be read to require Apple to give unimpeded access to iPhone hardware. I'm a recovering computer science major, and I know that can cause significantly huge problems. Apple would essentially have to weaken its operating system to provide a direct path for another business to have unimpeded access to the iPhone hardware. That means malware could exploit that path, get direct access to the iPhone hardware, and install viruses on your iPhone. And I just want to conclude again with the way that the report was generated. I commend their extensive work done on the report, except the report and the investigation focused on only 4 companies. How do we know Walmart.com isn't engaging in all sorts of anti-competitive practices, or Microsoft, or eBay, or Twitter, or Uber? And so it's sort of a circular definition to say, well, the reason we're only doing these bills on 4 companies is because we only investigated 4 companies. Well, the problem is there are other companies directly competing with these 4 companies that the subcommittee did not investigate. And so you're giving a massive advantage to every company that this subcommittee did not investigate by putting on all these restrictions on the only 4 companies that the subcommittee did investigate. So again, I think a better approach is if you deem a practice anti-competitive, then apply it not just to Amazon, but to other companies that do the same anti-competitive practice. With that, I yield back.
The gentleman yields back. For what purpose does Mr. Jackson Lee seek recognition?
Chairman, I have an amendment at the desk, amendment number 1.
The clerk will report the amendment.
And I have an amendment number 2.
Oh, one at a time.
Well, we're trying to move on.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Ms. Jackson Lee of Texas.
Without objection, the amendment is considered as read, and the gentlelady is recognized in support of the amendment.
Again, let me thank Mr. Cicilline and his co-sponsor, Mr. Gooden, for this legislation, and as well to the chairman and for the members who are here for this important historic moment. I rise to support. No, I'm doing number 1. I rise to support. Should have given out number 1. Number 1. Yeah. Ladies and gentlemen, it's number 1 that's coming to you.
Oh.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by
Without
Ms.
objection, the amendment is considered as read, and the gentlelady is recognized in support of the amendment.
Do all the members have number 1? It protects You have it, Congresswoman. Thank you. Again, thank you, Chairman, for the opportunity to explain my amendment to H.R. 3816, the American Choice and Innovation Online Act, which I'm proud to strongly support. My amendment is easy to understand and vitally important. It simply expands the prohibition on retaliation already in the bill to protect all persons who might raise concerns with law enforcement about a covered platform's violation of state and federal law, rather than only protecting business users and covered platform users. My amendment also expands the prohibition on retaliation to include retaliation for participating in litigation to enforce this act. This amendment is critically important because it expands protection to the employees and independent contractors of covered platforms, among others. It is employees and independent contractors who are most intimately familiar with an organization's business practices, and those are the individuals who are most likely to uncover potential violations of law. If retaliations for contacting law enforcement entities were not prohibited, it would have a chilling effect on the willingness of individuals to speak out upon uncovering such violations. Mr. Chairman, history is littered with accounts of brave individuals who spoke out when they discovered that the organization they were a part of was potentially violating the law. For Mark Felt, a former FBI officer who anonymously provided the Washington Post with critical information about the Watergate scandal, to Sharon Watkin, a former vice president of Enron Corporation, who raised the alarm about accounting regularities in the company's financial reports. Again, this is a very straightforward amendment. I ask my colleagues to support it, and I yield back my time.
The gentlelady yields back. I recognize myself in support of the amendment. This amendment clarifies the bill to improve the bill in that retaliation against certain parties, to clarify that retaliation against certain parties is not permitted. And I urge support of the amendment. And I yield back. Does anyone else seek recognition? If not,
Mr. Chairman.
Who seeks recognition?
Swalwell.
For what purpose does the gentleman seek recognition?
Move to strike the last word.
Gentleman is recognized.
Mr. Chairman, my concern with this amendment and frankly the bill is the scope. And let me begin by saying, essentially, if the scope was to include every American business, you would be telling Walmart or Target that they would have to carry any widget that any person wants to bring into their store, in addition to what that store would want to sell to its consumers. You would tell a Mexican restaurant that they would have to sell French food, and a French restaurant that they would have to sell Mexican food if someone came into their store and said, I want you to do this. It's called side loading as it relates to Apple. And the real scope here is that this is aimed directly at Apple and Amazon. And you are telling Apple that their curated app store, which is not a defect, but a feature that its users with other choices of Samsung, Google, multiple Chinese phones have signed up to use, would no longer be curated by Apple, but rather it would essentially be a flea market where anyone could bring any app into the store, regardless of security or privacy concerns. So the Chinese, for example, could flood the app store with apps that would allow the Chinese government to go all the way down the stack into all of our data. This new flea market style app store would also have no regard to the privacy restrictions, the high privacy standards that Apple has always had in place. I don't think we want to go there. There is enough competition in the market. And while Mr. Issa said earlier that Apple has, I think half of the iPhone, half of the smartphones in the United States, I don't think it's that high. Actually, as I said earlier, you have Samsung, you have Google, you have other Chinese products on the market. Consumers have choices. If they don't like the curated Apple store, they can go to the Google Play Store or the Samsung Store or the other devices. I will tell the committee that I have about 3,500 Apple employees who live in my district, but this is not a bias I carry. This is knowledge that I have from interacting with these employees and understanding what makes the secret sauce at Apple and how you would essentially break this brand because they would be required to do something that no other business is going to be asked to do. We're all aware of the Parler example after the January 6th insurrection, where Apple told Parler because they were allowing violence and messages of violence to be displayed on their platform, they would be deplatformed unless they cleaned that up. They were able to do that because this legislation was not in place. If this legislation is in place, Parler, with no restrictions, being a platform to allow an insurrection, goes right back onto the Apple platform, into the App Store. Also, I think it's important to note that only 70 of the 2 million apps in the App Store are Apple products. And so this is not a case where the store is flooded with Apple products and consumers do not have choice. Mr. Liu brought up an example about Amazon, and just 2 nights ago, I had to buy aluminum foil for our house. We've got a 4-year-old and a 2-year-old. We go through a lot of leftovers. I went on Amazon, and actually Amazon's choice, and if you all look this up right now on your phone, on your Amazon Prime account, Amazon's choice is not even its own Amazon product. It's a Reynolds product that Amazon features as Amazon's choice. So again, I don't accept that this is an abuse that is occurring, especially when you have so much competition in the market. So one final point, Mr. Chair, Apple's biggest competitor is a foreign competitor in Samsung, but Samsung would not have to comply with any of these rules. So we would make an American company that has thousands of American jobs here in the United States. They would be subjected to these rules while foreign companies would not. So that's why I'm going to oppose this bill. I would also ask to insert into the record a June 22 letter from Apple to the chairman, as well as a June 2021 white paper from Apple laying out their concerns.
Without objection. The gentleman yields back.
Yield back, yes.
Gentleman yields back. For what purpose? For what purpose does Ms. Hart seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I should not oppose this amendment, but I do have similar problem what some other colleagues mentioned with this bill. I think if we work further on this bill, maybe that could be resolved. But as of right now, there is some conflict of interest, and conducts can be outrageous and really can get to the level where they become unlawful. But what is good for the goose, it should be good for the gander, right? So we cannot just apply to some people and not apply to other entities. So I think if we evenly apply, if we believe this is a bad illegal conduct, if we believe it's bad, then it's bad regardless who is doing that conduct. And I think that is a big flaw with this particular bill. We shouldn't be just targeted to any particular entity. It's either bad or good, and we should decide and deliberate on some of these items. Some of them sounds pretty bad. But I think the whole application of that bill and really very concerning to me. So I'll support this amendment, and I don't know if we have, I think, a lot of amendments, and I'll be open-minded to this bill, but I think it's in the form like it is. I think it just really targets only a few entities, and we should apply law equally to all of the stakeholders. If it's a crime, it's a crime. If it's not, it should be applied equally to any, and not exempt anyone from the effects of the law. So I yield back.
The gentlelady yields back.
Mr. Chairman,
For what purpose does the gentleman from Rhode Island seek recognition?
move to strike the last word.
The gentleman is recognized.
I first want to thank the gentlelady from Texas for her amendment. I think it's an excellent one and improves the bill, and I strongly urge my colleagues to support the amendment. I also want to use this opportunity to respond to some of the issues that have been raised that I think, to be very frank, are part of the industry talking points. Nothing in this bill prevents Amazon Prime from existing. Nothing in this bill prevents pre-installed apps. With respect to Amazon Prime, that is a service that is offered both for Amazon products and third-party sellers. So it's not discriminatory. With respect to pre-installed apps, so long as those apps can be uninstalled and users have the option to do that easily, it's not discriminatory. And so if you look at the definitions in the bill that are included in the American Innovation and Choice Online, it will not prevent dominant platforms also from protecting user privacy and data security. In fact, the legislation includes explicit protections to ensure that covered platforms can protect user privacy and data security, to make certain these firms can stop malware, scams, and illegal conduct and prevent the spread of malicious content. I would understand my colleagues' concerns if this bill actually stopped a covered platform from these beneficial activities, but it does not. It is not anti-competitive for platforms to protect user privacy. It's not anti-competitive for platforms to protect the security of their ecosystems. And it's not anti-competitive for platforms to protect users from malware, scams, or illegal and malicious conduct. I'll repeat it loudly and clearly. The bill does not prohibit platforms from protecting their users. It does not prohibit platforms from protecting security. What the bill does is narrowly targets a discrete set of abusive and exploitative practices that dominant platforms engage in to disadvantage rivals and boost their own products and services. Time and again, these companies rely on buzzwords like privacy and security as a pretext to justify anti-competitive conduct. All too often, these firms use privacy as a sword and a shield. They justify anti-competitive conduct under the guise of enhancing privacy and security. They decry efforts to rein in their monopoly power by claiming it will impede their ability to protect user privacy and security. These claims are nothing but gaslighting. These companies are counting on their ability to scare us into doing nothing. This legislation before us will stop monopolistic practices by covered platforms and, importantly, will inject much-needed competition and dynamism into the digital marketplace. And the examples that have been given do not violate the statute. And again, the legislation was developed after an extensive record where we heard from small businesses about the unfair treatment by these large platforms that routinely favor their own products and services to the disadvantage of small businesses, often resulting in driving them out of business. This eliminates that, creates a level playing field to bring more dynamism, more competition, better results for consumers, more opportunities for small businesses, and more competition. And with that,
The gentleman yield for a question.
Will the gentleman yield?
Already yielded back to the chairman, but was that Mr. Jones?
Yes.
Yes, if I'm allowed to. Yes, Mr. Jones, I'm happy to yield to you.
Thank you. I want to sort of elaborate one of the points that you made, because we've heard more than one person say, well, why doesn't this cover Walmart? Why doesn't this cover certain other companies? And the fact is, conduct is only anti-competitive. And the size of the company, as well as the structure to that company. So let's use Walmart, for example, right? What separates Amazon from Walmart is that Amazon is both a platform and a seller, whereas Walmart is barely a platform at all. So Amazon's self-preferencing hurts small businesses in a way that Walmart's could never hurt small businesses. One, because Amazon hosts 50% of all online retail and an even larger percentage of third-party small business sales. So unlike Walmart, it has the power to decide whether those small businesses live or die. And second, Amazon has complete access to its third-party sellers' data, so we can copy them, kill them, or extort them. And so I just think it's important to clarify that, like, again, practices are only anti-competitive in the context of the size of these companies as well as the structure of those companies. And with that, I yield back.
I yield back, Mr. Chairman.
The gentleman yields back. Does anyone else seek recognition on this? In that case, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. The ayes obviously have it. The amendment is agreed to.
Chairman,
For what purpose does the gentlelady from Florida seek recognition?
from Texas.
Texas, I'm sorry, I keep doing that. From Texas, seek recognition?
I have an amendment at the desk, amendment number 2. I don't mind sharing with my sister.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Ms. Jackson-Lee of Texas. On page 1, line 17, amend section 2A3 by inserting before the period the following, quote, including those business users employed by businesses
Without
owned
objection, the
by.
amendment is considered as read, and the gentlelady is recognized in support of the amendment.
Thank you very much, Mr. Chairman. And I really, let me first of all thank my colleagues on the other side of the aisle for their support of the previous amendment. Excuse me for my raspy voice. Let me again thank Mr. Cicilline and Mr. Buck, and thank the chairman and ranking member of the full committee as well. And thank you for this opportunity to express my concerns, which I hope that I can draw up bipartisan support. My amendment is easy to understand. It's vitally important. It simply specifies that discrimination among business users includes discrimination against minority and women-owned businesses. Let me share some numbers with you. According to a 2014 special report by the Equal Employment Opportunity Commission, African Americans make up 7.4% of tech workers, Latinx make up 8% of tech workers, AAPI make up 14% of tech workers, women make up 36% of tech workers compared with others at 68.5%. After 6 years of diversity reports by the largest technology, it is clear that there has been difficulty in change. Without diverse employees, bias is a serious problem that creeps into artificial intelligence models, negatively affecting enterprises that use artificial intelligence tools and resulting in harmful consequences. As one extreme example, it was reported in 2015 that the Google image recognition algorithm was classifying African Americans as gorillas. It took Google 3 years to fix this issue, and that's due to lack of diverse employees. It is difficult to ensure that women and minority-owned businesses are not disadvantaged by algorithms designed primarily by others. Over the first 2 months of the health crisis, the number of active minority business owners plummeted. Black business owners dropped 41%, Latino business owners dropped 32%, Asian business owners dropped 26% as compared to the majority. This is a very small provision that I hope will get bipartisan support that simply emphasizes in a simple manner that the minority and women-owned businesses should, in particular, not be discriminated against. We hope that what we will do is increase the diversity, build on the economy, and as you well know, when you build on diverse communities, you build on the economic engine of America. So I ask my colleagues to support this amendment, and I reserve.
Will the gentlelady yield?
Which ways? I yield to the gentleman.
I thank the gentlelady, and I thank her for raising this issue because while her remarks relate to specific discrimination against women and communities of color, and the focus of the underlying bill is about economic discrimination, there is no question that the absence of competition and the crushing power of these monopolies has been particularly harmful to women and minority-owned businesses. And so I would ask the gentlelady if she would work with me to figure out what's the best language to make sure that we embed that in a way that kind of reflects the concerns you've raised in this bill and perhaps in others that we've considered tonight, because I think this is a very, very important issue, and I thank you for raising it. And I'd ask you if you would withdraw this particular amendment and commit to work with me before this reaches the floor to be sure it has a provision that reflects your concerns that you've articulated tonight.
Do I still have time? Well, as the gentleman knows, this is an extremely important issue to many of us and an extremely important issue to me. I would hope that this would have bipartisan support. I would look forward to working with the gentleman. I'd like to do so in the immediacy of this committee session so that we have language that we can work on that actually expands opportunity for minority and women-owned businesses, which I think the statistics suggest that there is a great need. At this time, I will withdraw the amendment.
The amendment is withdrawn.
Mr. Chairman,
Mr. Chairman.
move to strike the last word.
The gentleman is, for what purpose is the gentleman?
To move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I think the amendment offered and then withdrawn sort of raises something that is of interest. The gentleman from Rhode Island, I think a moment ago said that there are a series of discrete ways in which discrimination against business users is prohibited. And indeed there is. If you go down to subsection B of section 2, you got a lengthy series of them. You ban tying arrangements, you ban, you have a mandate, let's see, you have a derived data exploitation ban, you have a derived data access portability mandate, a hard default apps and services ban, an anti-redirect ban. It goes on at some length. But I think what the attempted amendment, or the tentative amendment that was then withdrawn, stuck in there at the end of subsection A, tends to point out is, what is the purpose of having A? You can't tell what it is that it bans, particularly given that you've got this impressive list of specific economic wrongs that are banned in subsection B. I don't think it's understandable, and I think it could mean anything. And as I said a long time ago now, this is another example of empowering regulators to make up something that none of us can possibly predict. And I'd be inclined to yield to the gentleman if he would be interested in responding to that.
Thank you, happy to. So section A reflects prohibitions on self-preferencing and exclusion. What's contained in subsection B are a set of prohibited conduct for which there's really no competitive justification. All of those things were identified during the course of the investigation. I think each of them, section B 1 through 3, 4, 5, 6, 7, are all discriminatory behaviors with no competitive justification.
I thank the gentleman in reclaiming my time. I guess what I think all of those discrete examples in subsection B are ways in which the covered platforms are not going to be permitted to preference themselves, but they're specific and therefore understandable. A doesn't add anything, and certainly when you get to A sub 3, it says it's unlawful for any person operating a covered platform to engage in any conduct in connection with the operation of that covered platform that discriminates among similarly situated business users. It's just indecipherable. It's so vague and vacuous that it leaves someone to make it up as they go. Unless there's somebody else who wants to take over, do you want to yield? I yield to the gentlewoman from Indiana, Ms. Sparks.
Thank you. I just wanted to echo that. It seems like this section is really broad, ambiguous, and have a lot of application, because what is really discriminate among similar situated businesses? It's very broad, and it seems like I can understand reading some of the other questions that is more particular about behavior, but interpretation is open to a lot of interpretations. So you can argue that, minority and women-owned businesses already included as part of that as a similar situated. You can argue anything you want, and it's really becoming very, there needs to be tight, and if this bill should proceed, this section really needs some work, because it really opens cans of worms with application, such a broad language.
Will the gentlelady yield for a question? I'm sorry, the gentleman.
I would yield to Mr. Cicilline
Thank you.
for an answer.
So I think, again, that language in subsection 3 discriminates among similarly situated business users, intended to create an even playing field and prevent platforms from picking winners and losers. But I agree with you that there's a lot of detail in the other discriminatory conduct in subsection B. So, we've accepted some of your amendments in the past. If you're saying striking 3 as an amendment would cause you to support the balance of the bill, that's something I would certainly contemplate. Because I think if that raises concern, I think it's clearly intended, that language is intended to ensure that platforms don't get to pick winners and losers and discriminate among similarly situated businesses. But if you're uncomfortable with that language, part of this process is deliberative. If it would earn your support to remove 3 and leave 1 and 2 intact, I'd certainly entertain that.
My time's expired. I yield back.
Gentlemen,
I take that's a no.
Gentleman yields back.
I have an amendment.
For what purpose does the gentleman from Ohio seek recognition?
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Reserve a point of order, Mr. Chairman.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to HR 3816 offered by Mr. Jordan. Page 1, line 15, strike.
Without objection, the amendment is considered as read, and the gentleman is recognized in support of the amendment.
Thank you, Mr. Chairman. Democrats have told us that we can't change the definition of covered platform, even though a week ago they changed the definition. They changed it in an effort to keep Microsoft out of the 4 companies that they want to have covered. Democrats told us that there's a burden shift for any mergers, and then they changed that and said, well, there's a burden shift for any mergers for the covered platforms unless they're merging with a company of 50 million or less. And Democrats said we have to give the FTC and DOJ more money, but we can't put any limits on how that money is spent. And then time and time again, they've said no to the most important question in my judgment. I think probably the most important question, certainly for the Republican side of the aisle, and that is the censorship of speech, the restriction on speech, the limits placed on free speech, the content moderation that is done by these big companies. So I'm going to try one more time. This amendment explicitly creates a private right of action. The amendment would prohibit a covered platform from engaging in politically biased content moderation. Time and again, we've seen big tech stifle viewpoints that don't align with their political ideologies, and all too often these viewpoints are conservative. If a person believes that they've been discriminated against by a qualifying company, they will be able to seek a remedy in federal court. If the person prevails, they will be able to recover actual damages, cost, and punitive damages. During the 2020 election, we saw big tech play politics under the guise of enforcing content moderation standards. Big tech is out to get conservatives, from elected officials to everyday Americans across the country. And this gives the average American a remedy. It's very similar to what the governor of Florida has done with the Florida legislature, empowering candidates, empowering people to bring causes of action when their content has been taken down, when it's been censored, when it's been restricted. That's all this amendment does. It seems straightforward. I hope that the majority will not once again say, oh, we can't deal with this. We can't deal with the most important issue when it comes to big tech companies, at least the most important issue I hear from my constituents. My guess is you all hear, and someone said this earlier, this whole thing, it's gonna, if it hasn't hit you yet, it's gonna hit everyone. So it seems to me, as I've said before, that this committee the Judiciary Committee should want to give American people an explicit private right of action when this, in fact, this kind of behavior happens to them on these platforms.
Would the
With that,
gentleman yield?
I'll yield to the lady, to the gentlelady from California.
It seems to me, and I will, we see this differently, and I will have an amendment that would cure the problem I'm about to point out. But I think your amendment is unnecessary because if you take a look at section 2A3 on the first page, you're in violation if you discriminate among similarly situated business users. So if you are doing content moderation for a particular entity, but not another, you're discriminating among the business users of the site. And because the remedy includes a private right of action for damages in the bill, you could sue under the bill without this amendment.
Yeah, I think our amendment's representing people too, not just business entities.
But an entity, for example, the Republican Party or Jim Jordan for Congress.
I appreciate that.
All of which you would have a private right of action
As a
to
political,
sue.
as a political entity.
Correct. And I thank the gentleman
But
for
I'm talking about as an
yielding.
individual as well.
I thank the gentleman for yielding.
You bet. I thank you. Mr. Chairman, I yield back.
Gentleman yields back.
Mr. Chairman,
For what purpose does the gentleman from Rhode Island seek recognition?
move to strike the last word.
Gentleman is recognized.
Mr. Jordan will not be surprised to hear that I oppose his amendment. I know he has tried a number of times to have a content moderation discussion, but this legislation does not involve content moderation. It's targeted at anti-competitive conduct in the digital economy. I understand that the ranking member has introduced legislation to address his concerns about this matter. That legislation has been referred to the Committee on Energy and Commerce. That is the appropriate venue for addressing these concerns. And again, this is about promoting competition online, which of course is the purpose of antitrust law broadly and the purpose of this statute, to prevent discriminatory behavior that favors the products or services of a covered platform, not about the content and content moderation. And again, there's a, pardon me? Yeah.
The gentleman yield
and
for a
with that,
question?
Mr. Chairman, I yield back.
Will
Will the gentleman yield for a question before yielding back?
are we
Mr.
allowed to?
Cicilline?
Can
I don't
we
think the chairman's
respond?
recognized that.
Did the gentleman yield back?
Mr. Cicilline?
The gentleman yielded back.
Can
For what purpose does Mr. Bishop seek recognition?
can you give me some time? Thank you, Mr. I thank the gentleman. Well, I would just,
Gentleman's recognized.
thank you, Mr. Chairman. Just responding to the gentleman from Rhode Island, I think the gentlelady from California said there is a right of action. She just said that's in the bill. Now you're telling me that we can't do it. Looks like you did it in your own bill. That's what Ms. Lofgren just pointed out.
It's to
And then-
business users, Mr. Jordan.
Pardon?
Applies to business users in the bill.
Well, I know, and I said that earlier. We want to extend it to individuals, and you're saying are you making a germane argument, or are you saying you're just opposed to it?
No, it's different. The bill prohibits it.
So you are making a germane argument?
No, I'm not making. I'm just opposing your amendment.
Oh, okay, I got it. So I would have a question for the gentleman then. Do you support the idea of the amendment I offered? I don't know if it was today or yesterday, but the amendment I offered
Earlier.
definitely earlier, the taking away the liability protection. Do you or do any of the Democrats support the idea of allowing an explicit private right of action for an individual and taking away the liability protection that big tech currently enjoys? Do you guys support that idea? Because you keep saying no to it in this context. I want to know if there's any context that you'll support that, because certainly, again, the constituents I get the privilege of representing, they certainly like that concept.
Will the gentleman yield? I'm happy to answer.
Of course.
I can't remember precisely your proposal, but I'm certain that I share the view put forth by Mr. Raskin, that I think we need reform of Section 230. That's a matter that obviously is not within the jurisdiction of this committee, but it's something I believe in strongly. I would be delighted to work with you, and I know Mr. Raskin would as well, to think, and Ms. Lofgren, what the right contours of that are. Just don't think that this is the appropriate place to do it. But
And how about this, if I could, Mr.
Sure.
Chairman, reclaim my time. How about the second question? Do you support this amendment that in a different context? I know you don't support it in this context, but in a different context, do you support a private right of action if in fact an individual's content has been taken down for political reasons?
I've explained to you my position on your amendment. You're talking about revisions to the content moderation rules governed by Section 230. I think that requires reform. I just don't think that's appropriate in this bill. I don't think your amendment.
I know you don't. I get that. I know you don't think it's appropriate in this bill. Do you think it's appropriate in a different bill?
I told you, I think we need to reform Section 230.
I'm not talking about Section 230 here. I'm talking about explicit private right of action. We have two different ideas. One is to take away the liability protection they have. The other is to allow you to sue explicitly.
I'm happy to have that conversation after the markup and talk to you about it. I have no sort of fixed views on it. I think reform is necessary, and making sure those rights can be vindicated is an important part of the conversation.
I think it's Mr. Bishop's time, but if you can yield to the
Could
gentleman.
you yield for a question, because it's getting late and it's hard not to feel grumpy, honestly, but I think what's being suggested, or the question that the ranking member is asking, is whether essentially he's saying discriminates among similarly situated businesses would be expanded to individuals who are discriminated against.
Exactly.
And that's, I am opposed to that, but that's what the issue that he's raising. Thank you for yielding.
Thank the gentleman for yielding. I yield back.
You yielding to me, Mr. Jordan?
I think it's your time that I'm yielding back to you.
Thank you. And excuse me, I'm getting choked up. My peanuts, which I do, mild allergy. I wanted to ask another question to Mr. Cicilline, if you'd yield to him, and that is his answer to the proposed amendment then withdrawn from Ms. Jackson Lee was that he thought there needed to be an amendment to deal with that issue in an appropriate way. That is to say, the notion of racial or women-owned business discrimination. Why not the same sort of treatment here? To have something that avoids discrimination on the basis of political motivation by virtue of politically biased content moderation.
Is that a question for me?
But he'd have to yield to
Okay,
you. That's
sorry.
I yield back to Mr. Jordan with the hope that he'll yield to you. Beg your pardon, I thought it was Mr. Jordan's time.
no,
It's
it's
been
yours.
yielded to me. So I'd offer to yield to you, Mr. Cicilline, if you'd like to answer.
Yeah, again, I think one of them relates to economic discrimination, which is what the purpose of antitrust and the purpose of this proposal that's before the committee right now. I think that's quite different. As I mentioned to Ms. Jackson Lee, the consequences to women and communities of color have been particularly devastating with respect to this market concentration. And I think that's an important issue, but that is different than the economic harms that are intended to be covered by this bill.
But you said you acknowledged that some amendment needed to be made to take account of her concern, but not Mr. Jordan's?
Yeah, because again, her concern relates to the economic implications for women-owned businesses and communities of color. His relates to content moderation for individuals. They're different issues. I yield back.
The gentleman's time has expired. The question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no. No. The noes have it.
Recorded vote on this.
A recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demmings? Ms. Demmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
Fancy glass.
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Mr. Jones votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat? Aye. Mr. Shabbat votes aye. Mr. Gomert? Aye. Mr. Gomert votes aye. Mr. Issa? Mr. Issa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Mr. Deutsch?
No.
Mr. Deutsch votes no.
Ms. Fishbach?
Yes, or I'm sorry, no.
Ms. Fishbach votes no.
Has everyone voted who wishes to vote? The clerk will report.
Mr. Chairman, there are 18 ayes and 24 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute?
Mr. Chair.
For what purpose does the gentlelady from California seek
I
recognition?
have an amendment at the desk,
The clerk will report the amendment.
15 XML, page 23.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Ms. Lofgren of California. Page 23, after line 5.
Without objection, the amendment is considered as read, and the gentlelady is recognized in support of the amendment.
Mr. Chairman, this amendment provides that an action taken by a covered platform operator shall not be considered unlawful conduct under subsection 2A or B of this act if it is good faith, non-pretextual, and reasonably tailored in its application of content moderation policies intended to restrict access to or availability of material that a covered platform operator or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, hateful, facilitating unlawful content, or otherwise objectionable, whether or not such material is constitutionally protected. Now, why am I offering this? If you take a look at section 2A3, for example, it is a violation to discriminate among similarly situated businesses. And there's no requirement that there be an anti-competitive aspect to it. It's simply the discrimination. On its face, that would allow a moderated business to seek redress. For example, recall a few years ago, Apple removed InfoWars, that app, from its app store for violating Apple's content policies, spreading misinformation and hateful content in bad faith. Now, they could bring a claim that similarly situated apps were left up on the platform and that they were discriminated against. Now, I know Mr. Cicilline will likely argue that the affirmative defense in the bill would protect content moderation policies, but I think that is uncertain at best, and that we would be much better off to affirmatively defend the right to moderate content. There's no stable body of law on this concept. And I would note that Mr. Buck said earlier in this markup that Google had changed its algorithm to advantage Mr. Biden and disadvantage Mr. Trump, which is the exact language of the bill in identifying unlawful categories of discriminatory conduct. Now, I'm very skeptical of that claim about Google, but the bigger point here is the very argument shows how content moderation decisions could be the subject of litigation. I do think creating disincentives to good faith platform actions is not a good idea. And if anything, the last few years have shown us that we need more content moderation because of the hateful sites and the violent sites that continue to be on these platforms. I recognize that my Republican colleagues will almost certainly oppose this amendment, and I accept that. But I do want to make an observation. While I think it's often grossly exaggerated, I do recognize there is concern about over-censorship by the platforms, and that my colleagues feel genuine about this, and certainly it is possible that there could be action, against perfectly innocuous activity. That said, it's simply not possible to have functional social media and other online services without at least some significant moderation. And the question is, how far should it go? What's too far? The devil is in the detail, and in that regard, antitrust will never really fix a censorship. Here I note that it's not just the dominant platforms who have policed hate speech and disinformation, also many other platforms from Reddit to Twitter to Discord and many other sites. But I do think it would be of value to us not to rely on the affirmative defense, the possibility that litigation will deter platforms from taking the steps that we want them to take, which is to moderate hateful content, to moderate racist, anti-Semitic, or content that incites to violence or other disorders. So I think this improves the bill. I hope that we can adopt it. And with that, Mr. Chairman, I yield back.
Mr. Chairman.
The gentlelady yields back. For what purpose does this gentleman from Rhode Island seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I oppose the gentlelady's amendment. This amendment is unnecessary because, again, this bill does not involve content moderation. A platform that applies its policies in a uniform way to similarly situated business users' standards would face no liability. So the amendment is unnecessary. You don't even need to get to the affirmative defenses. The American Innovation and Choice Online Act does not restrict the ability of platforms to moderate user content. The bills do not apply to user-generated content or online speech by individual users. They do not do anything to prevent a covered platform from moderating content by the individual users on the platform. The legislation only applies to the covered platform's conduct that affects businesses that use the platform. In short, the bill tells covered platforms they can have rules and they can enforce those rules, but those rules have to be applied evenly. And the platform services that use the platform have to play by the same rules as everyone else. Nothing in this bill prevents a covered platform from adopting or enforcing policies to remove hate speech, misinformation, scams, or illegal activity. A platform that uniformly applies its content moderation standards would face no liability.
Would
So
the
the
gentleman
amendment is
yield?
unnecessary. I urge my colleagues.
Would the
to
gentleman yield?
Sure, of course.
I understand that you believe that this is covered, but let me just make this point. If you have hateful content on YouTube and you're making money, you're running a business. And you might not be able to moderate all of the hateful content. Maybe you've only found some of it. InfoWars made money. It was a business, but not every right-wing hateful business was removed from the platform. Therefore,
In that
there was
instance, and just
discrimination.
reclaiming my time, in that instance, I would say to the gentlelady, that's in fact when the affirmative defense comes into play. But again, if you have a standard and that is applied evenly, there's no liability. With that, I yield back.
Mr. Chairman.
Gentleman yields back. Gentleman yields back. For what purpose does the gentleman from Ohio seek recognition?
Strike the last word.
Gentleman is recognized.
Yeah, the concern here is the two words, otherwise objectionable. That's the catch-all. That's where they can say, if you disagreed with what Dr. Fauci was saying last year, even though it looks like he was absolutely wrong about the origin of the virus, that they could take that content down. We had a long discussion from the gentleman from Texas talking about that issue a year ago. So that's the problem. And this is exactly the language we think needs to come out, needs to be dealt with in the amendment I offered again several hours ago relative to Section 230. So that's the concern here. And Ms. Lofgren wants to add that or keep that in. So I guess I'm with Mr. Cicilline in opposing this amendment, but I'm opposing it specifically for what it means to what these platforms can do to Americans' speech. That is the problem. That's the area that needs to change. That's what's in our legislation we introduced a week ago and the amendment I offered earlier or yesterday sometime. With that, I yield back.
Would the gentleman?
Yeah, I yield to Mr. Johnson from Louisiana.
I thank the gentleman from Ohio. I just want to say that, I mean, I'm just stunned. I know it's 3 o'clock in the morning, but everybody needs to pay attention to this, that this would, the otherwise objectionable phrase, of course, is a problem, but there's a lot here as well. It's hopelessly subjective language, harassing and hateful. What does that even mean? I mean, this is part of the problem with that we have with the big tech censorship right now, is that some people in a room somewhere determine what is appropriate to be online, which is the equivalent of the free marketplace of ideas now in the public square. It's the modern public sidewalk. I mean, for 20 years, I was in federal courts defending free speech, religious freedom, and the idea of free expression, and it was under assault. And we used to routinely go in and sue, public universities because they had these crazy, oppressive, hopelessly subjective speech codes, and they would say, a Christian student wants to, quietly, respectfully express what the Bible says about human sexuality, and it was deemed, hate speech or whatever, and they would try to, discipline them, and it was just blatantly unconstitutional. So I'm just saying, this is a Pandora's box. I would oppose the amendment too, just because, I mean, basically, why don't we just say we're going to give a license to the liberal operators of big tech to just censor and silence conservatives in perpetuity? Let's just make that a
Would my friend yield?
My friend,
Mr. Johnson yield?
I'll yield. Happy to yield. To Mr. Gomer.
Yeah, what about the language otherwise objectionable? I think that pretty well just leaves the door open to anyone who doesn't like what a conservative is saying, because we don't eliminate outrageous liberal speech. It's only
it's
conservative.
celebrated.
So otherwise objectionable, I think pretty well does embrace everything you're concerned about.
Yeah.
And it's if I can reclaim my time, it's further qualified. Otherwise objectionable, even if it's constitutional.
Right, there you go.
Shazam, whatever they want it to be, that's the standard. That's our concern, and it's been our concern the last 2 days. What we talk about has been our concern forever, dealing with what is happening to people's speech right now.
Would the gentleman?
I will yield to you, but I think the gentleman from North Carolina, and then I'll come to you.
Let me just point out one other thing. It's availability of material that a covered platform operator or user considers to be otherwise objectionable. So it may not be otherwise objectionable except in someone's extraordinary subjective judgment, and yet it still is covered. So, and I think it's the same issue we uncovered in the interoperability bill earlier tonight, which Mr. Massey, I think, observed. You cannot avoid this. And what all of these bills are doing, and again, I think it's most relevant to those Republicans who have decided to support these bills that confer all this discretion upon the FTC, is it locks in government control and government imprimatur upon this censorship that Facebook will describe as exercising content moderation in its humble discretion.
I would argue, and I'll yield the last few seconds I have, but I would argue, I think that's what the Democrats want. I hate to say it, but I think that's what they want. They've sent letters to the big carriers telling them to take certain networks off their platform. I mean, we had the gentleman from Maryland said earlier, he went on Fox one time and he thought it was a tough interview. Welcome to the world. That happens every time we go on CNN. But I don't write letters to carriers saying, don't carry CNN on your platform. I'm for free speech. I'm for the First Amendment. But it sure seems like the other party isn't, and that's the scary thing. And now the other party wants to give so much power to the FTC. That's what we're all concerned about.
Mr. Jordan, it sounds like we agree, so maybe we can vote.
Gentleman's time has expired. Mr. For what purposes? For what
Move to
purpose-
strike the last word.
You can take him first, I'll wait.
Who did? For what purposes Mr. Raskin seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
So at 3:08 in the morning, maybe we have begun to achieve some analytical clarity about what the real questions are here. I'm listening to Mr. Johnson, and it seems to me that he wants to treat any website on the internet as a state actor, as the government. And I just
No,
want to see whether that's the case. In other words, does everybody have a right to speak on everyone else's website or platform?
Would gentlemen yield?
By all means.
Here, let me give it to you in a nutshell, okay? Conservatives, as the gentleman from Ohio was saying just a moment ago, are for more free speech. We defend the free marketplace of ideas. We want more free speech. Our liberal friends, our progressive friends, want to restrict and censor and silence speech with which they disagree.
Then perhaps let me pursue it with you if we could, Mr. Johnson. The reason I raised the example of Fox News is it's a private corporation, and they very clearly wanted to censor my speech when they invited me on. Do I have a right to sue them for not allowing me to speak as much as the other people on the platform, or is it up to them? Is Fox News a speaker, or are they like the state? Are they like a marketplace of speech?
No, Fox News is a broadcast channel, and I probably would dispute that they censored you. I'm not sure about that. I've had rough interviews on CNN and MSNBC.
I agree with you, and I don't. But Mr. Johnson, you don't miss my point. What I'm saying is, Fox News is just like the websites that you're accusing of censoring conservatives. They are a speaker.
Okay. Sorry. All right. So clearly, Fox News is a private company.
They don't have two.
Jamie, my friend, what we are looking at here, the reality is that the big tech oligarchs, the online community, is the equivalent of what you and I used to talk about and teach in con law as being the quintessential public square. This is public forum now. I mean, it's the equivalent.
So let me ask you that. If you're saying it's a public square, you're saying it should be treated like the government.
No.
The First Amendment should apply against it, and everybody should have a right to speak there.
No, I'm
Is
not
that
saying
right?
that. I'm not arguing that, but I am saying
You just said it was the public square. People have a right in the public square under the public forum doctrine.
it is.
So I'm not trying to catch you up here, okay?
No, you're not catching me up at all. This is
conservative and Democrat, Republican, just reclaiming my time. My question is this: how do you want to treat the websites, and how do you want to treat the internet?
bingo.
Are you saying it is like government property and everybody's got an equal right to be there? Or are you saying that that private speakers are entitled to control their own speech? What is the analogy you're making?
So you have just, I think, illustrated the point that we've been trying to make for the last 12, 13, 15 hours, however long we've been here, that this is a very complex, unprecedented, unusual, brave new world situation that we have. We don't know what this is, and you and I could debate and discuss the contours of this for a month.
Mr. Raskin, will you yield for just a moment?
Well, wait a minute.
I will. I just to reclaim my time for 1 second, I just want to make the point. It can't be the case that if hate speech gets kicked off of a liberal platform, that is a First Amendment free speech violation. But if a liberal speaker gets kicked off of a conservative private corporate platform, that's just free speech.
Would the gentleman yield?
It's got to work in both directions. So you've got to decide what your analogy is.
Right.
Would the gentleman
And
yield?
do you want to treat all speech that takes place on the internet as an open public forum, like people going out to a park?
Would the gentleman yield?
But they're not treating it that way. They're not treating it that way. Yes.
Would the gentleman yield, Mr. Raskin?
Mr. Raskin, will you yield?
I'm going to yield to the gentleman from Rhode Island.
Thank you, Mr. Raskin. I think you've made the point that competition in this space is important because it gives people options. But we've had a long discussion about content moderation. That's not the purpose of the bill. I think we're all ready to vote. And I yield back to Mr. Raskin.
Right. And so, but I guess Here's the point we need to be clear about, okay? I know that some people view there being political mileage and whining about how they're victims and they have a victim complex and everybody's
one who did
discriminating against
that.
them and so on. The point
you
is,
just said you
if
were
we
censored
want to
by
have a
Fox.
discussion about content moderation at some point, let's have a serious discussion about it and decide whether people have a free speech right to speak on other people's websites if they don't want them there. And it can be right on left websites or left on right websites or whatever. But that is a very different question from the antitrust question, which is being posed here. And I yield back to you, Mr. Chairman.
The time has expired. For what purpose does Mr. Issa seek recognition?
I move to strike the last word. Steve, do you need to go first?
Gentlemen,
Go ahead.
gentleman's recognized.
Thank you, Mr. Chairman. I yield to the ranking member for a minute.
We're not the ones asking for networks to be taken off of the platforms. Democrats are. I didn't write the letter saying, are you planning to continue to carry Fox News, Newsmax, and One American News? Democrats wrote that letter. I didn't bring up Fox News today. Democrats brought up Fox News. Mr. Raskin brought up Fox News and said, oh, they mistreated me when I went on for an interview. I'll go on Fox News anytime you want.
Yield, please.
Mr. Raskin, I'll go on Fox News anytime you want. I'll debate you on Fox. I'll go on CNN and debate you. That's just, we're for, as Mr. Johnson, I think, eloquently said, we're for speech. We're for the First Amendment. You guys are the ones who want to stop it. You wrote the letter.
You
wrote the letter. Republicans didn't write the letter. I've never once said CNN shouldn't be on the platform.
Are you for Colin Kaepernick's free speech?
I'm for free speech. God bless America, right? There's a thing called the First Amendment. That's what I'm for. Yield back to the gentleman from California.
I think the gentleman, the gentlelady from California, Ms. Lofgren, you had something you wanted to say earlier.
I did, and actually I was just going to read the First Amendment, which is that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press, etc. These platforms are not Congress and they're not the government. They have the right to define the speech that's going to appear on their platforms. And they have policies, most of them. I believe, and I don't expect that you will support this amendment. I mean, because it goes in a different direction than where you think we ought to go. But my point is, for those of us who believe that there ought to be some content moderation, that there is some material out there that is polluting the mind of the public, driving people into, crazy conspiracy theories, leading them to attack the Capitol, that we would like that content moderated. And in my judgment, and I think Mr. Cicilline pretty much admitted that, if you have a business that is thrown off a platform and other businesses similarly situated are not, which is quite possible because content moderation is not an easy thing to do, then there's a cause of action and it will lead platforms to be less willing to moderate that content. And I think the remedy, from my point of view, I know you don't see it the same way, is to explicitly say that the content moderation is not covered by the discrimination discussed in 2A3. And I thank the gentleman for yielding.
I thank the gentlelady, and I'm more sympathetic to your goal than you might imagine. I'm not prepared to support the amendment in its current form, but I think it's it's an appropriate discussion. Hopefully, both sides can come to an understanding, at least as to the Republican position, and that is that we think that we should have more content, not less content, that when in doubt, it's fine to have a dissenting view. The idea that a particular treatment might have been helpful, and some medical doctors thought it was helpful for patients with COVID-19, and yet those were taken down because a platform made a medical decision in favor of one side's view or another. It worries me. I want to have more debate, and more importantly, if these platforms that hold themselves out to be immune from prosecution or civil suit for any prejudice or wrongdoing, If they say, well, look, we're not interfering with content except when needed because it's pornographic or threatening or et cetera, the famous example of fire in a movie theater, then they have to live up to that. And that's what we'd like to choose to have them do. I don't think that CNN has to welcome me on or not yell at me or talk me down. I understand these are private companies. The challenge is that CNN and Fox and the others are not immune from lawsuits for their action, and periodically there will be lawsuits, and they're meritorious. So my concern with this amendment is that I don't think it's well enough drafted to be narrow enough to meet the requirement of limiting it to the kind of prohibited speech that we could all agree on. And for that reason, I won't support it, but I appreciate the gentlelady's motives, and I yield back.
Gentleman yields back. For what purpose does Ms. Sparks seek recognition?
Move to strike the last word.
Gentlelady's recognized.
Just want to kind of echo Congressman Iser because, you know, give you an example. Amazon just recently decided, that they don't like some conservative writer. They decided to kick his book and not to sell it. And they have an opinion, and they're a private company. Ultimately, I would say, from my personal opinion, Karl Marx's Capital book probably caused more damage, and a lot of people died because of this very bad philosophy, but I will still defend the right to be sold, and I will not go and say them and object that they shouldn't be selling it. We should have not dictatorship of opinion. We should have an open place where people can have differences in opinion unless they're harmful and where a particular court said their opinion is bad, and I think the courts should rule on that. The problem what we have, we keep expanding immunity, and this is even gives a further immunity, which already this company have enormous amount of blanket immunity. If they're really private company, why do they even have then Section 230? I mean, if we're going to do that, we don't even really need them. Why should they even worry about the content, if they are really private entities? So we kind of have a double standard here, and I think we have to have that discussion because it's a very serious discussion. I don't have a problem what they do at private company. I have a problem that unlimited amount of immunity, and if they harm me as a business, I have no way to have a recourse in the tort law, and it's through courts. And I think our American system, based not on government regulations, but me as a business doing the right things because I have a liability, and you can sue me for wrongdoing, because government almost have no way to enforce all these rules or regulation. But if I know that I'm going to get sued if I cause harm, I will try to treat people properly and not violate their rights. And I think that is an important discussion we should have. And expanding immunity is really unreasonable, and it really suppresses the people who cannot afford to have expensive attorney, people who don't have the money to have this bohemia of legal system, to be stuck against them because it doesn't treat everyone equally. We either believe in the equality of rights or don't believe in the equality of rights. And the equality of rights, it doesn't give immunity to larger players and not to the smaller ones. And I think it's a very important discussion we should have. And I'm very happy to see that Congressman Cicilline is open to talk about Section 230 and Congressman Ruskin, because I think that discussion we should have as Congress. And I hope we can work on that. I yield back.
The gentlelady yields back. For what purpose does Mr. Shabbat seek recognition? Oh. For what purpose does Mr. Gomer seek recognition?
I move to strike the last word.
Gentleman is recognized.
And I appreciate the gentlelady from California pointing out what the First Amendment said, that Congress shall make no laws, and yet Congress created Section 230. That made a law, and it made these entities completely immune when they went about violating people's constitutional right. We gave the authority that I wish we would end to say, we're going to shut people down. We've got this town square. We assured Congress that we were going to let anybody speak, say whatever, as long as it was not constitutionally prohibited. And yet, once they got the immunity, here's where we moved, and apparently being encouraged by some on the other side of the aisle. So it is a congressional action that some of us say, sure, fine. They are free to choose anybody they want to speak on their platform or to shut down anybody they want on their platform. But the way they got to be such a big monopoly is by that immunity that Congress made laws to create. So we created the monster, and now we're trying to come up with legislation of how to rein the monster in, and yet we're still letting them keep the immunity that let them grow more powerful in some ways than the federal government. Now, the allegation about a victim complex, we don't have a victim complex. Just like Mr. Jordan said, you know, you go on CNN, they turn off your mic, they mistreat you, but none of us have said, oh, we're going to sue them, we want to shut them down, we want them kicked off any cable. Like Mr. Jordan said, we've never asked that happen. Now, some of us have sent letters wanting channels added, like One American News or Newsmax added, you know, Fox Business, things that are not always on. But we're not asking to discriminate and to take things off. We've been asking just for a fair shot. And until this committee gets ready to say, you know what, Congress really should not have made a law that discriminates, allows someone else to discriminate with our protection all around them, we need to pull that law back, Section 230, or 320 rather. And yeah, that's right, it's 230. Yeah, it's it's 320, 325, but that is a problem. And we could fix that, and I think you'd find a lot more harmony between both sides of the aisle if we weren't protecting entities that got to discriminate and eliminate free speech. And to put in the amendment, though, otherwise objectionable whether or not such material is constitutionally protected, that'd be fine if Section 230 were not there giving them immunity. But we've cloaked them in congressional protection, and then we're saying, you know, you can discriminate with our blessing, with our protection, and we'll protect you because we're not going to pull back your immunity. So you just keep on discriminating and eliminating free speech of conservatives, or even worse, what we've seen this week, there was a ruling that, you know, if you referred to biblical viewpoints, that somehow needs to be eliminated. It's somehow offensive. Man, we've come a long way the wrong way. But anyway, as long as 230 is there, given immunity, that's an act of Congress, and I'm hoping that the Supreme Court's getting ready to do what Congress should have done and say that is where we violated the Constitution, the First Amendment, and we got to get rid of it. So hopefully the Supreme Court will help. I yield back.
Gentleman yields back. For what purpose does Mr. Gates seek recognition?
Strike the last word.
Gentleman is recognized.
I agree with almost everything the gentleman from Texas said, but he took some liberty in suggesting that none of us on this side of the aisle would sue CNN. I want to make clear for the record that does not include me. I have been voting along with the bipartisan majority in favor of these bills, and if this amendment were to pass, it would drive me off the bill. The sponsor of the amendment suggested that this would allow us to combat conspiracy theories. Well, I remember saying that our own government had been weaponized against the President of the United States using illegal tools to try to destabilize an election that resulted in Donald Trump's victory. And folks said that was a conspiracy theory. Then we did some investigation and found out that it was not. I remember saying that COVID erupted from the Wuhan Institute of Virology, and the powers that be all suggested that that was a conspiracy theory. Now it turns out it might not be. The time we find ourselves in is certainly unique. I can't imagine that we would have a liberal Democrat from California offering an amendment to limit obscene, lewd, lascivious, filthy content on the internet, and then a Southern Baptist from Louisiana arguing against that amendment. It is certainly not the 90s anymore, because now we have the left in America trying to constrain what is accessible to people, not just in these areas of obscenity where there's well-developed law, but also just in defining the nature of truth itself. I believe that this amendment embodies the desire of the political left to embrace cancel culture and to allow tech companies to be able to define the characteristics of truth, to set the four corners of truth, to be the arbiters of truth. You know, I think that some of these platforms probably would have banned Galileo. And so it's essential that we not empower these platforms even more. I think that this amendment would do so, and that's why I'm voting against it, and I would encourage all of my colleagues to do so we could continue our great bipartisan progress. I'll yield to my friend from Louisiana.
The Southern Baptist from Louisiana. Let me just point out that we were just talking here, sidebar, it's very late and our wheels are turning slowly, but I mean, I think that Ms. Lofgren, read from the First Amendment, and of course the famous phrase there is abridging the freedom of speech, and I'm not so sure that her amendment on its face doesn't do exactly that, because you're empowering tech companies to ban, in your own words, material that is constitutionally protected. So this is an act of Congress, and therefore you're abridging the freedom of speech of people or empowering others to do so.
Would the gentleman yield?
Yeah, I'll yield to the gentleman from Texas for a moment. Turn your mic on, Chip.
I would just add to the gentleman in Louisiana that when you say Congress shall make no law, that's what we're talking about right here. Like this is the problem, right? We're not talking about the lack of the ability of a private company to say what they want to say or do what they want to do. We're talking about the act of Congress that is actually stepping on that's making the case. That's the whole point.
Would the gentleman yield?
Well, it's not my time to yield.
It's my time. I would observe before yielding to the gentleman from California that I believe we do need more than a legalistic view of the First Amendment. I think that we need to embrace the values of free speech in America, and that means that the terms of service on social media platforms shouldn't be more important than the values that undergird the First Amendment. I'd yield to the gentleman from California.
I realize we disagree on this issue, but just to be clear about the meaning of the amendment, under the bill, the capacity of these private companies to ban speech that they have decided not to host, violent speech, anti-Semitic, and the like, that would otherwise be protected were it the government, is diminished because of the Section 3, the discrimination and the private right of action. My intent was simply to once again empower the platforms to freely do that. You disagree with that, I understand that, but it's clearly that's what the amendment does, and I thank the gentleman for yielding.
No, I appreciate the explanation of that, and it is that reposing that power in these platforms when all of the work of Mr. Cicilline's subcommittee just shows how that power can be abused gives us, I think, enhanced reservation, and I yield back.
The gentleman yields back. Does anybody else seek recognition on the? The question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no? No. In the opinion of the chair, the noes have it.
Mr. Chairman, I'd like a recorded vote on that.
A recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demmings? Ms. Demmings votes no. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? No. Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
With great respect for my colleague from California, no.
Mr. Neguse votes no. Ms. McBath? Ms. McBath?
No, sorry. I was
Ms.
not-
McBath votes no. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Issa? Mr. Issa votes no. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes present. Mr. Johnson of Louisiana? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Bentz votes no. Mr. Owens? Mr. Owens votes no.
Mr. Chairman? Mr. Chairman,
Yes.
Biggs here. How am I recorded?
Mr. Biggs, you are not recorded.
I vote no.
Mr. Biggs
Mr.
votes no.
Chairman, how am I recorded?
Mr. Liu, you are not recorded.
Lou votes no.
Mr. Liu votes no.
Has everyone who wishes to be recorded been recorded?
Ms. Jackson-Lee, you're recorded as no.
Clerk will report.
Mr. Chairman, there are 5 ayes and 36 noes.
The amendment is not agreed to. Are there any further amendments to the amendment to the nature of a substitute?
Mr. Chairman?
Yes, Mr. Chair.
For what purpose does the gentlelady from California seek recognition?
It's their turn.
Oh, for what purpose does Mr. Benz seek recognition?
I have an amendment at the desk, Mr. Chair.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 3816, offered by Mr. Benz of Oregon. Page 4.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Page 4, after line 16, insert the following.
Without objection, the amendment is considered as read, and the gentleman is recognized in support of the amendment.
Thank you, Mr. Chair. This is a modest and simple amendment to the affirmative defenses found on page 4 of the bill. Currently, there are 2 affirmative defenses. Both require a showing by a clear and convincing evidence standard. The first is that if you can show that your conduct would not result in harm to the competitive process by restricting or impeding legitimate activity by business users. And the second one is a narrowly tailored, could not be achieved through less discretionary means. My amendment would add a third affirmative defense, which would be increases consumer welfare. The concept here is quite simple, and that is that under our current approach to antitrust law, we focus on whether or not competition leads to an increase in consumer welfare. If it does, then it's viewed as not being violative of antitrust principles. Thus, if we were to add this to the list of affirmative defenses, keeping in mind that it must be proven by clear and convincing evidence, a business who could show it was operating to the benefit of the consumers would not be subject to the discriminatory standards set forth in the section A and B of the bill. I think if you look at the definition of business users, you find, of course, that they are business people. And that's how the definition is set up on page 9, lines 17, 18, and 19. And so what we have is a clear reflection of the approach this bill is trying to use by saying that, as it currently written without my amendment, you are safe if you benefit business men and women, business users. I would add in the fact that we should also take into account consumers, since that is the proper focus and long-term focus over the past 40 years at least of our antitrust law. It seems to me, Mr. Chair, that we couldn't have a better comparison of what is underlying this bill than my amendment, because either we are only interested in benefiting business users, or we are interested in benefiting consumers. I think the better bet is consumers, and therefore I suggest everyone support my amendment.
Would the gentleman yield?
I would yield, yes.
I thank the gentleman. This is very similar to an amendment that I was going to offer and now will not, essentially providing that the benefits to consumers or end users substantially outweighs competitive harms. You know, it's interesting that there are times when the interests of competitors are at odds with the interests of the consumer. And in such a case, the consumer's interests ought to be considered. But in this bill, there's no consideration whatsoever for consumer benefit. For example, third-party websites don't want Google to put direct information boxes right at the top of the search results. They want you to always click through, but it might be more convenient for consumers. I love that Apple now has a thing where you can ask the apps not to track you. It's one of my favorite things that they've done. But that may not be something that would be competitive and might fall if your amendment is not approved. So I think there's a serious risk the law will end up protecting specific competitors to the detriment of consumers generally, and I'm grateful that you offered this amendment, and I yield back.
Thank you, and I would remind everyone that long ago when we started this hearing, and I was talking about another one of the bills, I referenced a case that was decided back in 1897, which talked about the focus of antitrust law at that time, which was upon benefiting small dealers and worthy men who should be protected, even if doing so came at the expense of a mere reduction in the price of the commodity. The point is, we moved away from that. And we moved away from that about 40 years ago, and we have focused instead upon benefiting the consumer. It's not perfect, and I want to take this opportunity to say how much I appreciate the efforts of those who have tried to address the challenges of big tech. These bills don't get us there, but it's hard to fault the effort. But I think
Will the gentleman yield?
I would yield. Go ahead.
Thank you. And I just want to associate my comments with the gentlelady from San Jose. I too will be supporting this amendment for the same reasons that she has stated, and I'll yield back to the gentleman.
Thank you, and I yield back, Mr. Chair.
The gentleman yields back. For what purpose does the gentleman from Rhode Island seek recognition?
To strike the last word.
Gentleman is recognized.
Mr. Chairman, I would just say that this amendment is redundant because in section C1, where this is added on page 4, it reflects harm to the competitive process, which includes consumer welfare as a kind of standard in antitrust law. So it's redundant and unnecessary, and I urge my colleagues to defeat the amendment.
Mr. Chairman.
Does the gentleman yield back?
But yes, I yield back, Mr. Chairman.
Gentleman yields back.
Mr. Chairman.
For what purpose is it?
Speak in support of the bill and strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. You know, the term "this is redundant," it's already in the bill. When I chaired a committee, my staff gave me that statement to make from time to time. But you can say in a bill something twice or 3 times, and it does not invalidate the fact that you might be saying it twice or 3 times. As a matter of fact, much legislation, in fact, repeats things again and again and again. It's not uncommon. This is not the Constitution. We do not have to make it super succinct to make it understood by a future court. And so I joined the gentlelady in wanting to say, even if some would say that there's a level of redundancy, I want it to be said that, in fact, if this is to the benefit of the consumer, if in fact it is more efficient and effective and drives down the costs of living and thus increases the value of a hardworking person's dollar and how far it goes, then in fact that is a benefit to our economy. And that has to be considered. More than 100 years ago, Sears and Roebuck, in fact, drove a lot of small businesses out of business, but it did not lead to a less efficient distribution system. It led to others forming companies to compete at that level. And it hasn't completely eliminated the mom and pop, but of course, we all understand that efficient distribution systems and logistics systems and computer systems that deliver high-quality goods at a good price on time to the consumer is now the standard around the world, and it was led by the United States. And it was led by Sears and Roebuck, but then it was led by Walmart, and now it is being led by Amazon. I believe that competition is generational. I think the gentlelady from San Jose is right to say that we have to consider this, and failure to do so would, in fact, persecute these companies without looking out for the consumer we claim is being disenfranchised by some of their activities. If what they're doing is anti-competitive and anti-consumer, that will be evaluated. But if what they're doing is in fact good for the consumer, truly good for the consumer, it has to be considered in the process. And so again, I join with the gentlelady in believing this is a good amendment. It makes a bill that I could not support less bad and perhaps even good enough for some people to change their mind on, and hopefully the authors would consider that. And with that, I thank the gentlelady for her thoughtful amendment and yield back.
It's not, it's his.
Mr. Chair, I'd like to.
Oh, I'm sorry, the gentleman's amendment, which the gentlelady spoke on. I apologize. She spoke so eloquently in favor, I got confused. Thank you.
Mr. Chairman, I'd like to move this strike to last word as well.
The gentleman yields back? The gentleman yields back. Who just,
It's Ted.
Mr. Lewis?
Congressman Liu, I'd like to move this strike to last word.
Gentleman is recognized.
Thank you, Chairman Nadler. I too will be supporting this amendment. I think focusing on the consumer is critical and is very important. And I also want to take this opportunity to respond to a member that somehow suggested that Walmart.com wasn't an adequate competitor to Amazon. I just want to enter for the record an article from CNN Business dated June 27, 2019. The title of that article is "Scathing Report Says Walmart's Grocery Store Dominance Must Be Stopped." And then the article talks about how Walmart has monopolized the grocery business across the United States. And then I'm going to read you this sentence. But growing pressure from rivals such as Amazon, Kroger, and Dollar General has forced Walmart to keep prices low and innovate. Amazon brought Whole Foods in 2017, and then goes on. And again, what this bill does, because the subcommittee never investigated Walmart or Walmart.com, it simply puts on all these restrictions just on Amazon, even though Whole Foods is competing with Walmart. Walmart.com is competing directly with Amazon.com. And to simply have not investigated a bunch of these online retailers, it's just not clear to me why we would do that. And so I think focusing on consumer harm and focusing on the anti-competitor practice. So if Walmart's preferencing its own branded product, and we think that's bad, then it should be bad for Walmart to do it, just as it's bad for Amazon to do it.
Will the gentleman yield?
That's why I support this amendment. I yield back.
Will the gentleman yield?
I'm sorry, I'll yield. I'll yield to whoever would like to speak.
I hope that we can agree that competing in the context of selling groceries is very different than the much more expansive context of Amazon.com, which sells all varieties of goods, right? And so I think that we're comparing apples and oranges here. My point remains that you have one platform, or one company rather, that has so much more of the market share than the other. And one is able to engage in what would legitimately be defined as anti-competitive conduct, whereas Walmart, I think for the intention of our antitrust statutes, is nowhere on that level, and I think is in a completely different league. And so I just, and it's not just Walmart, obviously, there's a whole bunch of other companies that I don't think should be falling into the coverage that some people at least have been suggesting. And I guess I'm curious to know what your response would be to that.
No, thank you so much for raising that. So that's why I entered that article into the record. Walmart is clearly not in a different league, for example, when it comes to food. It's dominant. And so we're somehow going to now allow Walmart.com and Walmart to do all these practices that we have now deemed unlawful and uncompetitive when Whole Foods does it. That's the problem, right? And also, we don't know if Walmart is dominant or Walmart.com is dominant because the subcommittee never did an investigation of Walmart or Walmart.com, or for that matter, eBay or Uber or Twitter, or I could go on and on. And so let me give this analogy. Imagine if the subcommittee said, hey, we're going to look at monopoly power in the airline industry. And the subcommittee looks at American Airlines, Delta Airlines, and United Airlines. And then it comes up with a bunch of bills that only apply to those three airlines. And we're like, hey, what about Southwest? And then committee says, well, we can't write laws about Southwest because we never investigated Southwest. But then you have the issue of you write all these laws just on three airlines, but not on the other ones, then you're going to give Southwest a huge unfair advantage. But the analogy is actually slightly worse than that. It's as if the subcommittee just investigated American Airlines, because Amazon is literally the only online retailer that the subcommittee investigated. And then it's putting all these restrictions on Amazon, but not on Walmart or Walmart.com. And so that's my point.
Ted, will
That's
you
why I
yield
support this amendment.
quickly?
I'll yield to Representative Swalwell.
Thanks, Ted. And I appreciate what Mondare's saying, but pull up Walmart.com right now. You'll see they're offering a credit card. They are offering a prescription drug benefit, and they are offering a grocery delivery service. So I don't think it's that much different from Amazon. And so that's just why I'm concerned that we have not fully delved into the likeness between the two companies. And I'll yield back to Ted.
Would the gentleman yield?
I hope that someone will.
I ran out of time, so I'll yield
Gentleman's
back.
time has expired. Who seeks recognition?
Mr. Neguse seeks to
Mr. Neguse, for what purpose does Mr. Neguse seek recognition?
move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I'll be very brief. I just wanted to jump in the colloquy here, or perhaps extend the colloquy between my good friend from California, well, both of my good friends from California, Mr. Liu and Mr. Swalwell, and my colleague from New York, Mr. Jones, because I do think that the distinction here is an important one. As I understand it, Amazon in this year, just based on a recent article, will represent 40% of the e-sale market in the United States. 40% entirely. Walmart will be second, and it's at 7%. So I think the distinction here is that Amazon, as we've discussed, repeatedly throughout the course of this hearing, and as was, I think, gleaned during the course of the subcommittee's investigation, ultimately is becoming, if not has already become, the marketplace itself. When a firm has 40% of the sales, of online sales in the United States, clearly it's moved past dominant, in my view. And I think that's what has animated much of the subcommittee's work in terms of the investigation that it did. And I'm happy to yield to Representative Jones if he'd like to expound on that further.
Thank you so much. Look, I mean, it is no answer to say that if you go to Walmart.com, you'll see them selling a couple of different products. But the fact remains that it is not large enough in terms of its market share and its dominance to be comparable, and even to rise to the level of being able to impact the market in a significant way. Certainly not on the scale of Amazon, the four big tech companies, which are, again, in a league of their own. It's why we have to limit the discussion to the grocery context to talk about the ways in which they are competitive as against each other. But we are looking holistically at the dominance of these companies in the market. And it's why we're not focused on a particular niche industry in which they happen to be selling their very specific products. And I'll just also add that the stat in that report was 50% and not 40%.
Would the gentleman yield?
I think it's
Yes, sorry, I was muted. Yes, I'd be happy to yield to the gentleman from California.
It just seems to me that the consumer benefit is obviously not limited to the fight between Walmart groceries and Whole Food groceries. There are times when you are theoretically discriminating among similarly situated businesses, but it helps or benefits a consumer. And I'll go back, I know Mr. Cicilline said that it wouldn't be the case, but there are people selling on Amazon's platform that are not eligible for Amazon Prime. And arguably, Amazon Prime would therefore be discriminatory towards those vendors. I like Amazon Prime, and I think a lot of Americans do. We've got Apple that is discriminating against other platforms that are trying to track across ad platforms. And that would theoretically violate the same section, and yet I think that does benefit consumers. In fact, that's moving us towards the privacy direction that we were trying to accomplish when Congresswoman Eshoo and I wrote the strongest privacy bill that's been introduced into the Congress in the last Congress. So I think it's not just this. It's if there is a benefit to consumer, that should be factored in. It shouldn't just be what's good for some other business competitor. And I thank the gentleman for yielding, Mr. Liu.
And Mr. Chairman, I yield back the balance of my time.
The gentleman yields back. Does anyone else seek recognition on the amendment? And the question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no. In the opinion of the chair, the noes have it.
We should have a recorded vote.
Recorded vote having been requested, the clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar? Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Ross votes aye. Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa? Mr. Isa votes aye. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes no.
Mr. Chairman, how am I recorded?
Ms. Escobar, you are not recorded.
Vote no.
Ms. Escobar votes no.
Has everyone voted who wishes to vote? Clerk will report. clerk will report.
Mr. Chairman, there are 22 ayes and 21 noes.
The amendment is agreed to. Are there any further amendments in the nature of
Mr.
the
Chairman?
amendment nature of a substitute?
Mr. Chairman, I have two amendments at the desk, which I would ask unanimous consent to consider en bloc.
Without objection.
The clerk will report. Yes, it's on page 1, line 7, and also on page 23, 013 and 016.
The clerk will report the amendments.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Ms. Lofgren of California. Page 1, line 7, strike, quote, any conduct, quote, and insert, quote.
The gentlelady is recognized to explain her amendments.
Thank you, Mr. Chairman. These are two amendments which, given the hour, I thought I would offer together. They're really quite simple. The first amendment moves harm to the competitive process out of affirmative defenses and instead requires it as an upfront element to establish unlawful conduct, discriminatory conduct under Section 2. The bill as currently drafted actually requires no proof or element of any anti-competitive intent or harm to establish unlawful conduct under the bill. This in many ways is the fundamental problem with the bill and the cause of its overreaching. If the authors of this bill believe in the standard of harm to the competitive process, then it should be a basic element to establish a legal claim under the bill. But at a minimum, it should be an upfront element, not a further burden on platforms to establish the only affirmative defense with clear and convincing evidence. The Second Amendment relates to actions that would permit platforms who are making a good faith effort reasonably necessary to protect the core privacy and security interests so that they will not be classified as unlawful conduct under Section 2. These bills closely regulate the platform's day-to-day operations and technical decisions, and that includes the platform's efforts to safeguard the security of user data and against other threats. Examples of platform privacy and security actions that could qualify as presumptive unlawful conduct under Section 2 include restricting third-party access to user data versus the platform's own access to such data could be construed as the platform advantaging its own services or disadvantaging those of third parties. That's in Section 2A1 and 2. Restrictions or impediments on third-party businesses accessing platform user data are broadly prohibited under Section 2B4, and restrictions or impediments on a business user interoperating or connecting to any product or service are broadly prohibited under Section 2B9. For example, under this bill, it appears to me that when Apple restricts the extent to which third-party app tracking of users on the iPhone, they may be able to challenge such privacy protections as unlawful discrimination against invasive advertising-based business models, and that's not something I think any of us want. In another example, alleged inconsistencies in the enforcement of platform privacy policies can become the subject of litigation as unlawful discrimination against similarly situated users. Now, I grant you, the bill does have an affirmative defense for actions taken to defend user privacy, but it's far too difficult to assert, and a platform can only prevail after months, if not years, of litigation, overcoming a heightened burden of proof, and let's recall that there is a private right of action on this. Further, the affirmative defense only extends to narrowly tailored privacy actions when the goal could not be achieved, quote, through less discriminatory means. Now, I think forcing platform actions on privacy and security to clear such a high bar is unwise. Introducing litigation risk and legal uncertainty is not necessary. And to the extent that I'm sure my friend Mr. Cistolini will say this is covered in the bill, let's make clear up front that these privacy and security measures are protected and that we actually want to have a standard of anti-competitive conduct as part of the initial screen for bad conduct. And with that, because it is after 4 a.m., I will yield back to the chairman and offer no other amendments.
I thank the gentlelady for yielding back. I recognize myself in opposition to the amendment, and I oppose the gentlelady's amendments. The gentlelady's amendments will make it more difficult for our antitrust agencies to enforce this act and stop anti-competitive conduct by covered platforms. Importantly, as the gentlelady acknowledged, this bill establishes an affirmative defense for conduct that does not cause harm to the competitive process or that was narrowly tailored, could not be achieved through less discriminatory means. It's not pretextual and necessary to prevent a violation of law or to protect user privacy or other non-public data. So privacy protections are built into the bill. Creating additional carve-outs as proposed in this amendment could serve to swallow the entire rule. I urge my colleagues to oppose the amendments. And with that, I yield back. Seeing no one else who seeks recognition, the question now is on the amendments en bloc. All those in favor say aye.
Aye.
Opposed, say nay. In the opinion of the chair, the nays have it. Are there any additional amendments? Oh. Yes. So, Ms. Jackson-Lee, I've conferred with Mr. Gates and Mr. Bucks, and there's been a discussion and I think a modification to the language she offered earlier, and to add including but not limited to those business users employed by business owned by women and minorities. Does anyone have any objection in adding that? Unanimous
Mr. Chairman.
So ordered. Unanimous consent. Okay. Mr. Roy, you're recognized.
Amendment at the desk.
Oh, gentleman has an amendment at the desk. Will the clerk please report?
Excuse me for leaning over you.
Amendment to the amendment in the
Ms.
nature,
Jackson-Lee reserves a point of order. I'm sorry, proceed.
in the nature of a substitute to HR 3816, offered by Mr. Roy of Texas, beginning on page 1, strike line 1 and all that follows through the amendment to the title on page 23 and insert the following. Section 1, prohibiting discrimination and distribution. The Clayton Act, 15 U.S. Code 12 at sequence, is amended by inserting after Section 28 the following. Quote, Section 29, prohibiting discrimination and distribution. A, definitions in this section.
I'm sorry, the gentleman is recognized to explain his amendment. My apologies to the clerk. Mr. Roy, you're recognized.
I thank the chairman. Obviously, given the late hour, I'll try to make this brief. It will not be new. This is the same as before, where I applaud the efforts and recognize.
You can never do that enough.
I'm aware that we know that there's discriminatory conduct that we all recognize the need to address. The only question is how. I've laid out my concerns about how we target certain companies and how that's going to be an evolving standard, and we'll be picking winners and losers. And my belief is we should try to avoid that. And I wish we were able to do that. And we obviously did not get the amendment earlier that I had worked with in conjunction with, again, Senator Lee and Senator Lee's staff. This is similar from the TEAM Act. This has got language that Senator Lee is advancing. And the purpose of this is to amend the Clayton Act to specify that a company with monopoly power in a distribution market that also offers a product or service in that market, like Amazon Marketplace, the Apple App Store, for instance, if that company has monopoly power in that distribution market, then the company may not engage in discrimination that harms competition. Again, the goal here is to try to look at the conduct. The goal here is to look at the market broadly, not to define the class of, 600 billion above and 500 million and so forth, which, as I've established before, is going to keep changing and put Congress in the ability, in the situation of having to chase where the market is. Rather, we should be focusing on the content and come up with standards that make sense to target the discriminatory conduct, or as before, when I was trying to address the issues of when certain mergers, certain acquisitions could occur. I think this amendment improves the bills in a number of ways. I think it brings the focus of antitrust back to monopoly power and practices that harm competition. I don't believe it's over-inclusive. I think it will not lump in practices that benefit competition and benefit consumers that I fear the other might. It takes the heavy-handed government out of the process. As a limited government conservative, I'm a little skeptical of empowering FTC and DOJ. Obviously, we had a debate over the fees use earlier. But again, I don't want it to be taken away that my belief that the good faith effort here to try to address discriminatory practice by my friend Mr. Buck and by the chair, the purpose of this amendment is also in good faith. I expect someone might be trying to raise a germaneness issue. I'm just going to go out on a limb and assume that may occur.
I believe it's already occurred. Ms. Jackson Lee has reserved that, but.
And I would just preemptively go ahead and address it by saying, as similarly as before, it's directly on point on the question. I understand the four corners, the technicality of how we deal with respect to germaneness, but this is the whole question. The whole question is how we do it, how we go about doing it. I mean, heck, you could raise the question whether the amendments in the nature of substitute are germane because of the nature of what they do. So I would just throw out to the committee that we should debate this, and I wish we would. I'll yield.
The gentleman yields back. Does the gentlelady press her germaneness objection?
I press and continue to object, and on the grounds that it is not germane. The amendment amends a law that the bill is not amending, so it is therefore not germane to this bill and at this time. I thank the gentleman very much, and I yield back.
The chair is prepared to rule. Clause 7 of House Rule 16 prohibits amendments that are on a different subject matter than the proposal that is under consideration. The subject of the bill we are currently considering is discriminatory conduct of covered platforms. The gentleman's amendment proposes to amend a statute not addressed in the bill, which is a subject that is different from what we are considering in the bill. The amendment is therefore not germane and violates Clause 7 of Rule 16. But as I did in the last amendment, I look forward to working with Mr. Roy and Mr. Buck and Senator Lee with respect to revisions to the Clayton Act, and we'll be sure to include this in that discussion.
I take the chairman at his word that we'll do that, and I appreciate it, and I appeal the ruling of the chair.
And you appeal the ruling of the chair? Right, but I'm saying I'm going to work with you to address this issue when it's appropriate. All right, we'll just do it by voice vote then. All those who support, I'm sorry. A motion to table has been made by Representative Lee. Those in favor of motion to table say aye. Opposed?
Aye.
The ayes have it. Motion's tabled. Thank you, Mr. Roy. Any additional amendments?
And I'd like to strike the last word.
Gentlelady is recognized.
Mr. Chairman, you were very generous but very fast, so I just want to make sure that it reflects that we did come to an agreement on the Jackson Lee amendment. We asked unanimous consent in this amendment number 3, which adds language including but not limited to those business users employed by business owners, businesses owned by women and minorities.
We have already done that, Ms. Jackson Lee.
By unanimous
Yes,
consent.
correct.
The amendment is in.
Correct.
Thank you very much, Mr. Chair. I just wanted to get a ruling
Yes.
that I could hear. Thank you. I yield back.
The chairman's back.
Are there any further amendments on the bill? Hearing none, the question occurs on the,
Mr. Chair,
for what purpose does
I have an amendment
Mr.
at the
Fitzgerald
desk.
seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Mr. Fitzgerald of Wisconsin and Mr. Issa of California. Page 4, after line 16, insert the following and make
Without
such...
objection, the amendment is considered as read, and the gentleman is recognized in support of the amendment.
Thank you, Mr. Chair. I'll be brief, and I worked on this amendment with Mr. Issa as well. He may have some comments on it. Because the bill would prevent platforms from doing the necessary vetting on apps, which was already discussed, to determine if they are operated by a foreign entity, and let's focus on the CCP, how would that information flow directly from China? Former director of National Counterintelligence and Security Center recently stated that China has stolen the personal identifiable information of 80% of Americans. There's big concerns about some of the apps that many kids throughout the U.S. have on their phones right now. This amendment would allow platforms to ban an app if it would likely result in data from another user being transferred to China or another foreign adversary. I'm not sure if Mr. Issa had comments.
The gentleman yield? The gentleman would yield.
Absolutely, yield.
Thank you. Again, one of the challenges with the bill in its current form is that we have now agreed to be interoperable with entities that are one-directional. And as we all know, in some cases, all they really want to do is scrape the data. But in this case, the gentleman's amendment seeks to ensure that your personally identifiable information, your proprietary information, is not sent to a foreign country, particularly an adverse one. And I think the most important thing is that it would likely result in data from another business user being transferred to. And that's the important thing is they can allow it to go to anybody, but not allow it to go out of the country to a foreign adversary, either directly or indirectly. It limits the interoperability, it limits the transfer, but it limits your data going where you didn't want it to go. You might choose to opt in for interoperability, but you're not choosing to have your information used by a foreign power, and that's why I support the amendment and co-sponsored it. I thank the gentleman. Yield back.
Will the gentleman yield for a question?
Yeah, yes. You.
Is there a portion of the bill or federal law or the amendment that defines what constitutes a foreign adversary?
It's not further defined, I think, than other than what you would find in the bill itself, so, no.
Would the gentleman acknowledge that our foreign relationships are at times complex and definitionally it would seem challenging to have to determine who's a foreign adversary pursuant to the amendment?
Absolutely. Yeah, I mean, that's part of the question is how do you make that determination? And then, how much of that software possibly had made its way through the states? I mean, that's our big concern is, as soon as we heard that TikTok was on every kid's phone in America.
Would the gentleman yield again? I think the important thing about the gentleman's amendment that makes it make sense is in light of the other portions of these bills where the Federal Trade Commission and its committees are deciding things, where the Federal Trade Commission has authority, we certainly have the ability. In addition, the chair has the ability to make technical and conforming decisions. So this is a principled item, and if Mr. Gates, as one of the co-authors of much of this legislation, feels that it needs to be more clear, that's not difficult. But it's very clear that the gentleman's amendment is really about people's privacy and their rights and platforms being able to protect that. And so that's the reason I support it. And I think it's well enough written for everyone to understand. Yield back to the gentleman.
Mr. Chairman.
The gentleman yield back.
you have another? I would yield. Yield back.
Does the gentleman yield back?
Yep.
Gentleman yields back. For what purpose is the gentleman from Rhode Island seek?
Move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I'll be brief. First of all, the amendment, first of all, Mr. Gates's point about foreign adversary not being defined, it is not, the FTC is not authorized to make that definitional determination. They are a highly qualified agency, but clearly not equipped to do that. So I think there's a very serious problem with that. But even more fundamentally, it's drafted incorrectly because it currently says sections A and B shall not apply if the defendant establishes by clear and convincing evidence that the conduct described, and then it lists 1, 2, 3. So they would have to, the defendant would establish by clear and convincing evidence that the conduct described in subsections A and B would likely result in data from another business being transferred to China. So you make an affirmative defense if the user demonstrates it actually goes to China. It's exactly the opposite, I think, of what you intend to do. So I urge my colleagues to vote against the amendment.
Gentleman yield back.
Yield back, Mr. Chairman.
Gentleman yields back.
Mr. Chairman.
For what purpose does the gentleman from Ohio seek recognition?
Strike the last word and.
Gentleman is recognized.
Just to support the gentleman from Wisconsin's amendment, it's interesting that, we're raising questions about defining a foreign adversary. I think we know what foreign adversary is. It's China, it's North Korea, it's Russia. But there's all kinds of words in the bill. We don't know what the definition of advantages are. We don't even know what discrimination is. We're gonna leave that all up to the FTC. We don't know. We had a big debate on how you define interoperability. There are tons of terms that aren't defined that the FTC is going to define, but suddenly now we're going to make an issue of foreign adversary? Those are the bad guys out there who want to do harm to America. I'll define it. I think the gentleman from Wisconsin knows what the term means, but somehow now we can't take this amendment because foreign adversaries, we can't define that.
Will the gentleman yield for a question?
Countless number of terms in the bill that we haven't defined, and we've had hours and hours of debate on those. But suddenly now it's, foreign adversary has to be defined. I just fail to see why.
Will the gentleman yield?
I'd be happy to yield to my friend,
Is
good friend.
Pakistan a foreign adversary?
Yeah, you want to include them in? Go ahead. You can define it too. You can define it too.
Mr. Jordan, I'm asking you because you're a supporter of the amendment and you just debated that you know what a foreign adversary is. So I have a series of questions as a member of the Armed Services Committee.
Pakistan is.
Okay, is Turkey a foreign adversary?
I don't know that one. Maybe, but
I'll yield back to the gentleman.
I'll ask you a question. What is advantages? What is disadvantages? What's discrimination? What's interoperability? How are we going to define all those terms?
Well, I think those are far easier to define than a foreign adversary for the FTC. The gentleman from Ohio and the gentleman from California have been spending a good portion of the last 20 hours telling us that the FTC should not have the ability to define these digital interactions, and now you would give the FTC the ability to define what constitutes a foreign adversary, and even you don't know what constitutes a foreign adversary by your own admission in this colloquy.
You don't know countless other terms in the bill you've been supporting, all the bills you've been supporting, and you're going to give all that power to Lena Khan.
It is a different question to define technical terms within the jurisdiction of the FTC and to literally use the FTC to define international relationships. The sponsors of this amendment must understand facially that it is improperly drafted, and to maintain that this is somehow definable at some later time when the gentleman from Ohio can't define it, when the FTC couldn't possibly define it, strains credulity.
I yield back.
The gentleman yield.
I'll be happy to yield.
Thank you. I thank the gentleman for yielding. Mr. Chairman, a lot of people are going to say it's difficult to decide that, but I will say that it was defined in the last administration repeatedly. Wilbur Ross defined it and used the term and gave examples of countries at that time. In this administration, they've already used multiple times the term foreign adversary. And I will agree with the gentleman from Florida that, in fact, at a given time to say this is an adversary or that is an adversary may not be possible, only because from time to time who our adversary changes. And so the term foreign adversary is often used not for our permanent adversaries, which seem to be Iran and North Korea, but for the shifting sands of who we can trust and who we can't. And when it comes to data security and when it comes to the idea that it's going to be used against us, yes, we have decades of China and Russia being foreign adversaries, but we will from time to time have countries that become adverse. So the term foreign adversary is very appropriate. It has been used by administrations back to at least before Truman, and have been used by the last administration and already used repeatedly by this administration. And I thank the gentleman for yielding.
Mr. Chairman, I yield back. Well done.
The gentleman yields back. I recognize myself in opposition to the amendment. In addition to the reasons stated by the gentleman from Rhode Island, in addition to those amendments, I find myself in agreement, I think, with Mr. Gates. The term foreign adversary is impossible of definition. It is impossible. China may be an adversary today. In World War II, it was a great ally. Russia was an ally in World War II. Today it is an adversary. One writes legislation for the ages or until it is amended. One doesn't write legislation that is impossible of definition because the term changes all the time. Therefore, I must agree with Mr. Gates and Mr. Cicilline in opposition to this amendment, and I yield back. The question occurs on the amendment. Oh, for what purpose does Mr. Royce seek recognition?
Move to strike last word.
Gentleman's recognized.
I would only say, Chairman made a really good point about the underlying bill structure of 600 billion, 250 billion, of the many variables that you could stick with throughout the bills. That's the point of that flexibility. This, I think China's going to be an adversary a lot longer than 600 billion will be the standard. I yield back.
Gentleman yields back. The question occurs on the amendment. The question occurs on the amendment. All in favor say aye. Aye. Opposed, no? No?
No.
The noes have it. Yeas and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar? Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa? Mr. Isa votes aye. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Yes.
Mr. Massey votes yes. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Owens? Mr. Owens votes yes.
Mr. Chairman, how am I recorded? It's Raskin.
Mr. Raskin, you are not recorded.
I vote no.
Mr. Raskin votes no.
Are there any members who wish to be recorded who have not been recorded? The clerk will report.
Mr. Chairman, there are 15 ayes and 26 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a
Well,
substitute?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Report of order. Reserve a point of order.
No.
Point of,
I think Zoe has more.
the point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Mr. Fitzgerald of Wisconsin and Mr. Isa of California. Page 4, after line 16.
Without objection, the amendment is considered as read, and the gentleman is recognized in support of the amendment.
Thank you, Mr. Chairman. As the freshman offering this second time, I wanted to make the point that we heard you loud and clear, we heard the objections, and we have now struck, or another foreign adversary. And the bill now says simply, would likely result in data from another business user being transferred to China. I don't think we have any question about China being a current adversary and even an existential threat. Our president, President Joseph Biden, has already made that clear. It is clear that, in fact, we have a foreign adversary that we cannot trust, one who is scraping our data, one who is, in fact, trying to eat everyone's lunch, including these four, and if given the opportunity, will. So it's very straightforward. It is not what we might have wanted, but we do not want to be expansive for expansive sake, and therefore we heard you loud and clear. We've made the secondary amendment, and we now offer a perfected amendment with the hopes that it will be taken in the spirit in which it's given. And with that, I yield to Mr. Fitzgerald. Do you want to comment further on it? I yield.
I'm in full support of what. Would the gentleman yield?
I would yield to the gentleman from Louisiana.
Just to play devil's advocate here, how do we determine likely results? I mean, what's the objective criteria on that? I mean, I'm all against China. We're going to vote unanimously for this, I think. But, I mean, how do we... the problem is that there's so much subjectivity in this whole package of bills.
And I agree with the gentleman that it is difficult. But it is clear that every day in the cyber world, our companies, including these 4 large and many much smaller, and including, by the way, every one of your servers being hosted here at the Capitol, are dealing with attacks from China. So do we know that China is an adversary? Absolutely. Do we know there's a likelihood if you deal directly with Alibaba that you're going to have it taken? Yes. Will China use surrogates, and will companies have to play cat and mouse to determine that? Absolutely. And that's the reason that it says that these 4 companies will have the ability to make that. That can be second guessed, that it's not being abused, but it's pretty clear that every day they're in battle with China, and so are tens of thousands of other companies and millions of Americans. So I appreciate the gentleman's question. I think that by narrowing it to China, we have no doubt that they are every day attacking everything, including every one of our sites that we use as members of Congress. Tens of thousands of times, hundreds of thousands of times, they attack the House of Representatives every day.
But is this a known or should have known standard? Is that what you would, I mean, how is that to be determined? I still don't know the answer to my question. Maybe there is no answer to it.
There's no question at all that would likely result is less than could result, might result. So it's very clear that these companies are not in a position where they can lackadaisically say, well, anything could result. They have to have a level of confidence that it would likely result, which is a standard that is well understood in the law. Is it variable? Yes. Is it certainly one in which we would know that doing business with Alibaba or other Chinese companies directly that are owned by the Chinese Communist government would clearly lead to that. And of course, our government works with all 4 of these large companies on a cyber basis, cooperatively, so they do share data. And the federal government, many departments of the federal government, share with these companies and vice versa. As a matter of fact, Google operates on behalf of the federal government with cleared personnel. So there's no question at all that there is a synergy in which these companies, for all their shortcomings, are some of the most qualified to know what, in fact, is likely to go to the Chinese. And I appreciate the gentleman's question. I think is well thought out.
I yield. Thank you.
Mr. Chairman.
Does the gentleman yield back?
If no one else seeks my time, I would happily yield back.
And Mr.
The
Chairman,
gentleman yields back for our
withdraw my
purposes. The
point.
gentleman from,
I withdraw my point of order.
point of order is withdrawn. The amendment is.
No,
For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman is recognized.
And before Mr. Issa got too smug with Mr. Fitzgerald, he actually didn't fix the amendment because it provides an affirmative defense if the defendant establishes by clear and convincing evidence, and it adds this. So if the defendant establishes by clear and convincing evidence that the conduct described in subsections A and B would likely result in data from another business user being transferred to China, they then have an affirmative defense available to them. I don't think that's what you intend to do. I urge my colleagues to vote against this amendment. Mr. Issa corrected half of it, but left the other part exactly as it is. I urge you to vote no. I yield back.
Gentleman yields back. For what purpose does the gentleman from Texas seek recognition?
To delightfully strike the last word.
The gentleman is recognized to delightfully strike the last word.
Thank you. With that, I would yield to my friend from California.
I thank the gentleman from Texas.
Delightfully.
I'm sure that if I had said would likely not result in data from another business user being transferred to China, the gentleman from Rhode Island would find it just as objectionable. So the fact that it's an affirmative defense, yes, we want to have these 4 large companies have affirmative defenses when they are in fact protecting data from being transferred to a hostile competitor, a hostile country that means to in fact eat our lunch militarily, economically, and in every other possible way. This is a country that has developed specifically the ability to take our satellites out of space, to shut down our communications, to build islands, to, in fact, take back Taiwan by force. The list is endless. But in this case, it is, in fact, their stripping of data, their cyber attacks that, in fact, should give these companies certain abilities to defend on behalf of all of us. And I trust that the gentleman from Rhode Island would agree that China is, in fact, a clear and convincing threat. Our president has said so. I would yield to
Only that your amendment doesn't achieve that objective, but
and so I would query the gentleman if I said would likely not result in.
with all due respect, Mr. Tyson, I'm not going to rewrite your amendment at this late hour. I oppose it.
But you know, I can scratch it and submit another one. I just want to know.
Happy to work on it with you before it goes to the floor.
You know, we're here and we've got all the time in the world. It's a new day.
It is a new day, but I'm happy to work on it with you before it goes to the floor, Mr. Tyson.
Yeah, but you know, the problem is even the Supreme Court, when they turn things down, generally tell us why. I remember the stolen valor. They didn't like how we did it, but they told us what was wrong, so we as a Congress, you were here, could pass a new bill that protected against that kind of statement. I only say that if you're going to say no, then in fact, the question is, do you want to protect, to give these people the out to protect from China or not? Because you're not going to work with us in good faith if that's...
Mr. Tyson, I've never offered to work on an issue having worked in good faith, and I wouldn't start tonight. So I promise you, I'm speaking good faith.
But with the remaining two and a half minutes, the question is, what is it that you find technically wrong with this? So would not likely result. Could I get 30 of these, please? I'm pausing. It's that poignant pause that it takes to get 30 copies of the change.
You have 1 minute and 44 seconds left in your pause.
Mr. Chairman, if I may inquire during these minute of remaining time, how much further you think we can get before we have to vote on the floor on today's bills?
I don't know, but we're going to persist until we finish our business.
I'm looking forward to that, and I hope we don't have to adjourn anytime soon. I suspect they won't have votes before 8 or 9 in the morning, would you think?
I think we're good to go.
Does the gentleman yield back?
Oh, no, I'm pausing for the moment. Sometimes an opportunity to think and for people to reflect can be productive. Yes, 6 billable hours, that's true.
For some members, that may be a new experience.
Yeah. Yeah, it's the pause for thought, Mr. Chairman. That could be reflective. And with that, Mr. Chairman, I urge support of this first amendment, or second amendment as it is, and the third one soon to come, and I happily yield back.
The gentleman yields back.
Mr. Chairman, I call the previous question.
The motion on the previous question, on the ICE amendment or on the bill?
Has to be
On the bill.
On the bill.
No, you can't do that.
Chairman,
There is a
amendment before.
there is a pending amendment. There's a pending amendment.
Questions on the amendment.
Are we ready to vote on the amendment?
Then I call it on the amendment.
I think the question occurs on the amendment. All in favor, say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the noes have it.
No, we can't. We have to finish this one first.
Is recorded vote requested?
Mr. Chairman, the ayes have it. The noes have it. Mr. Chairman, I have another amendment at the desk.
Mr. Chairman, I call the previous question.
Wait.
I call the previous question on the bill.
The gentleman from California moves the previous question on. Well, wait a minute. Did we take a recorded vote on that?
Well, there's not a pending amendment right now.
So why can't he move the previous question? On the bill. On the bill. We can move it on the bill. Let him do it. The gentleman from California moves the previous question. The motion on the previous question is, you move the previous question? We'll suspend for a moment. You didn't vote. For what purpose does Mr. Ice seek recognition?
Chairman, I have a final amendment at the desk.
Reduced to writing?
It is at the desk. It's reduced to writing.
Mr. Jordan
It's my final amendment.
unanimous consent that we'll consider these two final amendments.
Point of order, Mr. Chairman. What happened to Mr. Swalwell's amendment to call a question?
He wasn't recognized for that purpose.
Mr. Chairman, I seek recognition.
The gentleman from California is recognized.
I call the previous
Not
question.
that, I'm sorry. Mr. Issa is recognized.
Mr. Chairman, I have an amendment at the desk.
Gentleman will
It is
state.
my final
Clerk will
amendment on
report
this
the-
bill.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Mr. Fitzgerald of Wisconsin and Mr. Issa of California. Page 4, after line 16.
Without objection, the
insert-
amendment is considered as read, and the gentleman is recognized in support of the amendment.
Mr. Chairman, I will not waste any of the committee's time. This final change is well understood. It changes it to not, which the gentleman from Rhode Island kindly agreed would be the fix, at least for the intent. So regardless of whether it's going to be voted up or down, I think it's understood and would urge that it now be accepted, and I yield back.
The gentleman yields back. Does anyone else seek recognition on the amendment?
Mr. Chairman,
For what purpose is the gentleman from Rhode Island?
move to strike the last word.
Gentleman is recognized.
Once again, now Mr. Ice's amendment would provide that all the prohibited conduct is now permissible so long as it would not likely result in data from another business user being transferred to China. That clearly doesn't make any sense. So I urge people to vote no.
Yeah, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. No.
No.
In the opinion of the chair, the noes have it. The yeas and nays are requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes no. Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch.
No.
Mr. Deutsch votes no. Ms. Bass.
No.
Ms. Bass votes no. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell.
No.
Mr. Swalwell votes no. Mr. Liu, Mr. Raskin,
No.
Mr. Raskin votes no. Ms. Jayapal, Ms. Jayapal votes no. Ms. Stimmings, Ms. Stimmings votes no. Mr. Correa, Mr. Correa votes no. Ms. Scanlon, Ms. Scanlon votes no. Ms. Garcia,
No.
Ms. Garcia votes no. Mr. Neguse,
No.
Mr. Neguse votes no. Ms. McBath,
No.
Ms. McBath votes no. Mr. Stanton,
No.
Mr. Stanton votes no. Ms. Dean,
No.
Ms. Dean votes no. Ms. Escobar,
No.
Ms. Escobar, you will have to turn your camera on.
Sorry. Nope.
Ms. Escobar votes no. Mr. Jones,
No.
Mr. Jones votes no. Ms. Ross,
Mr. Chairman, how am I recorded?
Mr. Jeffries, you are not recorded.
No.
Mr. Jeffries votes no. Ms. Ross, Ms. Ross votes no. Ms. Bush,
Bush votes no.
Ms. Bush votes no. Mr.
Madam
Jordan,
Clerk, Madam Clerk, this is Hank Johnson. How am I recorded?
Mr. Johnson, you are not recorded.
Vote no. Thank you.
Mr. Johnson of Georgia votes no. Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Shabbat? Aye. Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa? Mr. Isa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes yes.
Mr. Chair, how am I recorded?
Mr. Liu, you're not recorded.
Lou votes no.
Mr. Liu votes no.
This is Congressman Cohen. How am I recorded?
Mr. Cohen, you're not recorded, but you will have to turn your camera on.
Well, I think I can't. Nobody should look. Oh, no!
Mr. Cohen votes no.
The ghost from judicial past. Ah!
Can you ask how Ms. Bass is recorded?
How is Ms. Bass recorded?
No!
How is Ms. Bass recorded?
As no. I voted.
Ms. Bass, you're recorded as no.
Yeah.
The clerk will report.
Mr. Chairman, there are 20 ayes and 24 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? For what purpose does Mr. Fitzgerald seek recognition? Clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3816, offered by Mr. Fitzgerald of Wisconsin. Page 4, after line 16, insert the following and make such technical and conforming changes as may
Without
be
objection, the
appropriate.
amendment will be considered as read, and the gentleman is recognized in support of his amendment.
Thank you, Mr. Chair. In 2018, over the objections of big tech, Congress passed the Stop Enabling Sex Trafficking Act, an amendment to fight online sex traffickers known collectively as FOSTA/SESTA. These bills give victims the ability to hold internet platforms accountable for facilitating sex trafficking. I'm concerned that this bill would undermine these protections by making it more difficult for platforms to remove apps and users that facilitate sex trafficking. My amendment would fix this by allowing a platform to remove the apps that do not comply with the standards set in Fighting Online Sex Traffickers, Stop Enabling Sex Traffickers Act. Urge my colleagues to support the amendment.
Mr. Chairman,
Does the gentleman yield back?
Mr. Chair.
Gentleman yields back. For what purpose does the gentleman from Rhode Island seek recognition?
move to strike the last word.
Gentleman is recognized.
I thank Mr. Fitzgerald for this amendment, and I appreciate the intention. The good news is it's already covered in the existing text. If you look at number 2, it was narrowly tailored, could not be achieved through less discriminatory means, was non-pretextual, and was necessary to prevent a violation of or comply with federal or state law. This is a federal law, so it's already included, so it's unnecessary to pull out this particular statute. But yeah, it's important to include it in the legislative history, but I yield back.
Gentleman yields back. Are there any further amendments?
Well, Mr. Chair.
This is, I move to strike the last word.
Gentleman is recognized.
On this amendment, which is still under debate, once again, people love to tell us that something's covered, and I appreciate that, but saying it twice on something as important as this does not seem to be a problem. This certainly would not negate the first time if it was said again. So I strongly support that, since it will do no harm, and we certainly want to do good when it comes to preventing sex trafficking. I certainly think that the gentleman has hit the nail on the head, and I would hope that saying it twice is appropriate. And with that, I think the gentleman yield back.
Gentleman yields back. The question occurs on the amendment. All in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it.
Yeas and nays.
Yeas and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen?
No.
Mr. Cohen votes no. Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa? Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Present.
Mr. Massey votes present. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes yes. Mr. Isa, you are not recorded. Mr. Isa votes yes.
Are there any members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 18 ayes, 25 noes, and 1 present.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? The question occurs on the amendment in the nature of a substitute. This will be followed immediately by vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no.
Aye.
In the opinion of the chairs, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill, H.R. 3816, as amended, favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably. The ayes and nays are requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen?
Aye, aye, aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass?
Aye.
Ms. Bass votes aye. Mr. Jeffries?
Aye.
Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Stimmings? Ms. Stimmings votes aye. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones?
Aye.
Mr. Jones votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush?
Aye.
Ms. Bush votes aye. Mr. Jordan?
Yes.
Mr. Jordan?
Oh, this is, no.
Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Isa? Mr. Isa votes no. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
Nay.
Mr. Biggs votes nay. Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stube?
No.
Mr. Stube votes no. Mr. Tiffany? No. Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes nay. Mr. Bishop? Mr. Bishop votes nay. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Bentz votes no. Mr. Owens? Mr. Owens votes yes.
Are there any members who haven't voted, who have not voted, who wish to be recorded? The clerk will report.
Mr. Chairman, there are 24 ayes and 20 noes.
The bill is, the ayes have it, and the bill is amended as ordered, reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. The committee will now stand in recess until 11 a.m. this morning, when we will take up H.R. 3825.